we have a hurricane that's looming again, unfortunately, for Wednesday evening. So everyone, please be safe and protect themselves. And for those who've been involved in the hurricanes over the last month or so, we definitely keep those folks in our prayers and the struggles that they're going through. This meeting is being streamed on YouTube with a 15 to 20 second delay. Today's meeting is being recorded as approved by the board. I would also ask for a moment of silence for the victims of COVID-19 and the healthcare workers that treat our fellow citizens during this crisis. Thank you. Ms. Jacinta has volunteered to read our mission statement this morning. Ms. Jacinta, you have the floor.
Good morning. The mission of the Louisiana State Board of Medical Examiners is to protect and improve the health, safety, and welfare of the citizens of Louisiana through licensing, regulation, research, and discipline of physicians and allied health professionals in a manner that protects the rights and privileges of the licensees.
Thank you very much, Ms. Jacinta. I'd like to invite the public comments to be emailed to publiccomments@lsbme.la.gov. Again, publiccomment@lsbme.la.gov. I'd like to remind our staff and board members that your mics will be muted and to use the raise hand function to be recognized. I also ask that once you've recognized, please state your name before speaking. I also advise you that if you mute, your mic is on mute, and you mute yourself, we may not be able to unmute. Please be aware of that. You may notice some changes on the executive session information. These changes are to protect the due process right of the affected practitioners. Additionally, we must ask that any additions to the executive session agenda be made now or any time before the completion of the public session. We will no longer be able to make additions to the executive agenda after the close of the public session. Also, all public session agenda items need to occur before we begin the executive session. These changes will be made on the advice of our counsel from the AG's office. And speaking of that, I'd like to thank and introduce Ms. Patricia Wilton, Ms. Suddeth, and Ms. Angelique Friel, and thank them for their continued help in this transition from the Attorney General's office. Dr. Collada, Mr. Phillips, are there any comments at this time?
No, sir.
Okay. Yes, sir.
I said none that I've seen.
Okay, thank you. If there is any motion at this time, please make them. You must recall that it must be a unanimous consent vote to add any item to the agenda at this time. There are a few additions that I have been meeting with Dr. Collada last evening that I would support as adding as agenda items. The first would be to move 1.05.01 to the executive session. Item 1.05.01 to the executive session. Could I have and this was done, this is being asked for council is asking us to move this item. Could I have a motion to that effect?
Weather so moved.
Dr. Weather?
I have a question. Yep.
Well, let's have a second, then we can have a question, please. Do we have a second?
I just don't know which one we're talking about. That's all.
No, we don't have the agenda up.
Oh,
And
well, we can't because it's an executive session item. I think, Ms. Wilton, would you like to speak to this, please, this morning? Or Ms. Patricia?
Certainly. Good morning, Patricia Wilton. It was on the agenda that you previously received. We would ask that it not be posted publicly because we do believe that there are some details on there, and the issue that it's about it was inadvertently placed in the public session. It is appropriate for it to be in the executive session because it arose out of a complaint and also because some of the documentation have some names involved that we would not normally share in a public session.
Does that answer your question, Dr. Valentine? Is that sufficient?
Yes.
Yeah.
Okay, all right.
can you give me the page number where it was on the agenda?
Hold
Page
on
I
one
think
sec.
page 45,
45.
page 4 or 5.
45.
Okay.
Okay, thank you. That works. We can, all right. Thank you very much.
Do I have a second? We kind of jumped ahead before the second. We went to the discussion.
Second,
All right, that was Ms. Sport, I guess. Any further discussion or questions from the public? Or comments, excuse me, from the public?
No, sir.
All in favor, say aye.
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 All in dissent? Hearing none, the motion passes unanimously. The second is that's an item that we would like to add to the agenda for discussion. Discussion this morning is that more recently over the weekend, a petition of the legislature to end a declared health emergency to put this as an item on the agenda. Dr. Collada, would you like to speak to this briefly?
Very briefly, this was an event that took place late Friday afternoon. The effect of it is that we now have differing opinions between the legislative and the Department of Justice of the state executive as well. And so we're faced with the possibility that all of our temporary permits would cease to exist. And so we need to address this issue today and have a plan of action for this as it evolves, because I'm sure it will be in the courts today or tomorrow.
Do I have a member who would like to move on this, please? This item? A motion?
Sport
So
moves.
move Valentine. Valentine second.
Dr. Valentine has second. Ms. Sport has made the motion. Any discussion? Hearing none. Any comments from the public?
No, sir.
All in favor, please say aye. Aye.
Aye.
Aye.
Any dissension? Hearing none, it's unanimous consent. Passes. The third issue is to add to our docket calendar the issue of logistics for hearings on Tuesdays. Do I have a motion? This would be an executive session.
So moved. Kim
Ms.
Sport.
A second. Dr. Thomas is seconded. Any discussion? All in favor, please say aye.
Ms. Wilton has her hand up, Dr. Clark.
Okay. Yes, Ms. Wilton?
I'm sorry to interrupt, Dr. Clark. I do apologize, and I couldn't figure out a way just to ask this. Are we actually in the open meeting at this point, and have we called the roll?
We didn't, they said, I think we had what I had heard from Dr. Collada is that I assumed it was we had a quorum, but we can call the roll if you wish. If you think that's appropriate. Dr. Collada, please call the roll to reaffirm.
Dr. Weather,
Here.
Dr. Johnson. Dr. Johnson, I see him waving his hand, but I need you to unmute and speak. You are
Can you hear
unmuted.
me?
Yes, sir. Present.
Okay, I'm here.
Dr. Horton,
Dr. Horton is absent, but she will be joining us in a bit. She had to go to court.
Dr. Yu,
Here.
Dr. Thomas,
Here.
Dr. Clark,
Yeah.
Ms. Sport,
Here.
Dr. Valentine,
Here.
Dr. O'Neill,
Here.
Dr. Taylor. Dr.
Here.
Taylor. You have
Here.
9 of 10. You have a quorum, sir.
Okay, that reaffirms what you had told me earlier that everyone was here, and I assumed that Miss Dr. Horton is not. So thank you, Ms. Wilton, for having us reaffirm that. Again, we're in the middle of a vote to post a new item on the executive agenda under the in executive session on the Tuesday meeting hearings under the docket calendar. And I don't know if I had a motion and a second on that or not. I can't recall. Ms. Sport, I think, motioned. Did I have a second?
Dr. Valentine seconded the
Valentine
motion.
Is that, she did? Any discussion? All in favor, say aye.
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 All in dissension, nay. Passes by unanimous consent. There is an item that is Judge Becknaris. I was unable to contact Judge Becknaris. It's my fault. I need his cell phone number. Judge, you're on the line this morning?
He's on the line.
Judge?
Yes,
Good morning, sir.
morning.
I see there is no action item. I know there was some activity after the last meeting of the last month. Do you plan on presenting anything today in regards to that, to September today?
No, we drafted an opinion, and I'm going to speak with the board members as it relates to the opinion that was drafted to find out if there was any modification that was necessary, or if I accurately expressed their judgment on the case that was tried on last month.
Okay, so I just wanted to be sure that if we needed to put you on the agenda, that you would be there. So it's no need to add you today. Okay,
No.
well, thank you very much, sir. All right. Okay, well, thank you all again. And before I move on, though, are there any public comments?
No, sir.
All right. Okay, now that we've got that housekeeping out of the way, I need a motion to approve the minutes from July 27th, August 5th, and September 28th. Dr. Thomas, would you like to comment on any of these? Because I know last meeting you had some issues.
No, I think we're in a good place.
Okay. Is there any additions or corrections to the minutes that need to be made? Hearing none. Is there a motion to accept the minutes from July? Do we have to do each one individually, Dr. Collada? Can I just accept the minutes in total from those 3 months?
I think it would be cleaner if you did them individually, sir.
Okay. So do I have a motion to accept the minutes from July 27th, public minutes?
Weather, so moved.
Do I have a second?
O'Neill, second.
Dr. O'Neill, any discussion? Hearing none. All in favor say aye.
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 Any dissension? Motion passes. Next up is August 5th, 2020 minutes. Do I have a motion from the floor to accept?
Moved.
So moved,
moved,
Dr. Thomas. Dr. Thomas, second. Do you have a second?
Weather,
You, second.
Dr. Yu?
you.
All right. Any discussion? All in favor, say aye.
Aye.
Aye. Any dissension? Hearing none, motion passes. September 28th, 2020 minutes. Do I have a motion to accept those minutes? Please. Do I have a motion?
So moved,
So
Thomas.
moved.
Dr. Thomas, and seconded by
Second,
who?
Sport.
Ms. Sport. Any discussion? All in favor, say aye.
Aye.
Aye. Any dissension? Hearing none, motion carries. Thank you. Are there any comments from the public at this time?
No, sir.
Thank you very much. Any hands raised that I need to look at here this morning? Okay.
No, sir.
Dr. Collada, you're now recognized. Follow-up action items.
One moment as I roll the screen down for. lost it. Just give me 1 minute, sir. I apologize. If you could take another item of business, my computer winged out.
Your computer wigged out on you, huh?
That's a technical term.
Well,
I'm having to reload the agenda. I'm about halfway done. I'm ready to go on, but I can move with from.
hello? Did we lose
No, I just can't display from the other device right now.
you?
I
Okay, well,
apologize.
I see it load. I see something loading.
Yeah,
here.
it should be done in just a few seconds.
We'll give you 5 seconds, Van. Just take a deep breath. This is like my computer logged off too while I was. It's just the way it rolls.
There we go.
Okay, so it's page, let's see here, 40 to 44. Page 40. All right, Dr. Collada, you're on.
This is the draft response that was drafted in request by a psychiatrist about the PECs. This was prepared with our legal staff, and it meets the requirements of the law in conjunction with what you all were suggested. And so I would move that we go ahead and approve this.
Any discussion from the board on this letter? I think we talked about this at a large discussion at the last meeting over this issue. So if there are any board members who would like to speak to this topic, please do.
I'm sorry, I wish I could turn this part of my brain off. This is Dr. Thomas. There are just a few little typos. So on page 41, the paragraph that starts while, on that second line, instead of the word assistance with ANCE, I think that should be assistant with a T at the end.
Thank you, Dr. Thomas. Any other corrections that you see? Please do
Yes,
make them.
the next paragraph that starts off with you. And then it says, let's see, you also, it says ASK, ask. I think it should be the past tense. You also asked.
Any objections to those corrections? I think they're friendly amendments.
And then that next paragraph that begins with finally.
Okay.
So physician assistants, the plural of that is the S on the end of assistant. It doesn't need an apostrophe S on physicians.
Agreed.
That's it.
Okay, I think those are friendly amendments. No need for a motion. Would we need a motion to approve this letter to be sent out? Do I have a motion from the floor? Dr. Thomas, would you like to make the motion to us to approve this letter to be sent out, or someone?
Or, yes.
Dr.
So moved.
Okay, Dr. Thomas, it moves. Second.
Sports second.
Ms. Sport is seconded. Any further discussion? Any comments from the public?
No, sir.
Without getting in, this is O'Neill, since Dr. Horton's not on, being a psychiatrist, I can understand why this guy's concerned. This is a legislative matter, not a decision of the board. But I feel strongly. Physicians do these things. You're taking away people's rights for up to 15 days. It's done willy-nilly in much of the state, and it's concerning that we're taking people's rights and putting them in locked psychiatric units with very, and I see this all the time. at University Hospital, and it's disturbing, but I think it's a legislative issue. This was done through the legislature, and we have little we can do about it.
Okay. Thank you very much for those comments. Yes, ma'am. There's a lot of background noise from somewhere. Excuse me, Dr. Valentine. Alan, you may want to mute some mics and leave Dr. Valentine open. I hear a lot of clatter. Dr. Valentine? There we go.
Yes, no, I was, thank you. I wanted to just echo what Dr. O'Neill said. I think he's absolutely right that this is a concern and that rights are taken willy-nilly, to use his phrase, but it's absolutely appropriate. And I think it is a concern that would require a legislative remedy.
Thank you very much for your comments, Dr. Valentine. All right, I need to have a vote. All in favor, say yay. Yeah, aye or yay?
We're all muted. Yay.
Okay.
Yay.
Undo the mics.
Yay.
All right. We'll try this one more time. All in favor, say yay or aye.
Yay.
All right. All in dissension? Hearing none, it passes. Thank you very much. President's report, as usual, I'm privileged to report that the board is doing well. I think the actions that we've taken over the last few months have definitely affected the boards and the staff's ability to perform at a higher level. So I appreciate the board's good works as usual. I know we're all working to try to do what's best for the citizens of Louisiana and for our licensees. Today, we continue those efforts with some process and organizational improvements. I would hope the board would reaffirm the president's authority and the job description of the executive director, and also ask for the approval of the job description of our compliance council and our organizational chart that we've been working on and discussing for many, many months. A lot of hard work and deliberation by the board has given direction to creating these documents. And so we'll be reviewing those, and hopefully we can get that taken care of today.
Hello?
Yes? Oh, that's Dr. Collada. Van, could
Yeah,
you
go
mute
ahead.
yourself?
Yeah, I'm sorry. I'm on mute.
Mute yourself. Thank you. I've tasked our executive director and staff to present in December a plan for our licensees in developing a mental health plan with a budget so that we can move towards hopefully affecting this issue. I've also asked our staff to present at least 2 action plans to satisfy the legislative auditor's concerns and investigation oversight. And and probably the last thing that we will probably have on the agenda in December but it's a big one. We need to move forward with a discussion of hiring counsel for our investigations department and how we're going to handle that going forward. So just to give everyone a heads up about what's coming up in December, after hopefully we can get past these other issues today that have been lingering and have been on our table for a good while. Sometimes you just have to do your best and move on. And I think that's what I would ask the board to do today. I'm moving things out of order a little bit. I would like Dr. Collada to present his executive director report, and then we'll go back to those action items that I discussed that we need to handle today. But I'd like him to get his executive director report out of the way first. Dr. Collada. Unmute yourself, please.
I'm trying to bring it up on the screen for everybody. When you take it out of order, I got a little confused. I apologize.
That's okay. I didn't warn you, did I?
No.
I'm good at that.
Okay. All right. So we are in the midst of the second extraordinary session that ended actually on Friday. And when I wrote this, we were in the midst of it. We had it was moderately chaotic, to say the least, with 70 plus items on the call for a 4-week session. And the most important things that I want to call to your attention as of the printing of this, but we added one in the item of discussion later on, is Senate Bill 27 by Senator Barrow Peacock and Senate Bill 63 by Senator Regina Barrow. Both of those are attached for your review. Senate Bill 27 now brings Louisiana into the medical compact licensing for physicians. And this was, while we gave testimony, it was pretty much something that everybody wanted to do. They think it's a great idea. And so what we will have the opportunity based upon this law to start to operationalize it, identify any problems, and it's not impacting us as an agency until July of 2021. However, the maker has said that if we find any real significant problems, he would take this back to the legislature to either correct them or take us out of the compact. And I will tell you, we will be working with him to do whatever we can do to make him see the problems, and it'll be up to him to decide. Senate Bill 63 by Senator Barrow was to give pharmacists the authority to do point of care testing for specific conditions yet undefined and initiate treatment. We testified that we considered that to be the practice of medicine and that we did not feel that this was something that pharmacists should do. We felt it would set up a double standard that would not be necessarily equal, and people would be getting diagnosis and treatment without actual physical examinations, taking of histories, et cetera. The bill was turned into a study resolution, and the resolution was promulgated at the last couple of hours of the session. And unfortunately, we can be consulted. We do not have to be consulted. But I have worked with Malcolm, and we gave testimony at this time that we have a long-established program of the collaborative drug therapy management, which would seem to fit the needs of this kind of request. But we'll see what happens in the future as the study proceeds. There were many bills to curtail, restrict, or modify the governor's authority or to declare or extend executive orders. And as you know, we talked about this a little earlier, we'll discuss it later. They did pass, instead of a bill, they passed a petition, which was something that arose out of the sessions after Katrina, to be able that because many of the legislators then thought that we were kept in the declared emergency much too long. And this gave the right, if the petition passes the House, then it terminates. And as we alluded to earlier, we'll discuss the net effect of that later on when we get to it. During the most recent storms, the agency has experienced no problem. Surgeon Water Board has replaced our water meter due to its lack of reading, and we'll probably see a rise in the bill because they had some changes to the meter to make sure that they got better readings. The building renovations are proceeding, and we hope to see completion in early to mid-December. The investigation ordered by the board in February is proceeding, and you may be contacted by the attorney investigator, Ms. White. This is Ms. Christine White. In order to resolve some of the problems that we're all having connecting today, we have new laptops, and they're ready to be distributed to all of you. They do require the use of a dual-factor authentication system to protect everybody's data. One of the things we would remind you today, if you have downloaded any of these materials onto your computer, at the end of the meeting, you should delete them. If you're on a company computer doing this, remember that if you don't delete them, the company has access to it, and possibly even if you do delete them, the company could recreate those files and find out what's in your file, because you do not own the data if it's on your corporate computer where you're an employee. So we're going to give you these secure computers. They will maintain all of the data in a secure environment. And the difficulty is we can do this by phone if you want to share some answers to questions with us. If you feel you don't want to share those answers with our IT professionals, then you'll have to come to the office to get set up. We have a couple of people who are in the process of being set up. I know we think we delivered one to Dr. O'Neill already. And I think we're in the process. We should have everybody ready for the December meeting. It'll be much easier for you to get everything on your computer and be ready to roll, and you'll be able to log in much more efficiently. It seems like it's less efficient, but in reality, it's much more efficient when you get started. So the setup by phone is explained to you, and if you choose to come in, we'll do that for you. This will be the last month of the download system for your private computers. And again, this is necessary to secure our data. Again, I remind you, please remember to delete any of the files that you downloaded, especially for hearings, etc. And we have started the notice of CME change for 2021. And we've had about, probably 250 to 300 phone calls, most of which I have been fielding a lot with licensing. And most of the people are, once we explain to them what we're doing, have been more than happy. I've only had one person who seems to think that this is unnecessary. He is thinking about whether he will resign. And I said, I understand, but we have 35,000 licensees we have to track. And so we're going to be doing that. And we appreciate that. Dr. Denner's contract was finally approved by the procurement office, and she has returned to work, and she's here with us today, and we welcome her back. At this point, I have nothing else in the executive director's report unless you have any questions about it.
Any comments from the public or questions from the board?
Dr.
Yes.
Clark, there is a comment from Jeff Williams.
All right. All right. What is it? What is it? Van, can you read his comment, please?
I'm sorry, I'd have to get to it. Let me 1 second.
All right. Well, okay.
Can Alan read it? Because Alan,
yeah. Alan, you can. Please, Alan, go ahead.
It's concerning APRN's areas of expertise. It said, is surgeon, nurse practitioner advertising the item that moved to executive session? If so, I submit the comments below and would also like to know any outcome decision reached from your executive session. Nurse practitioners who complete an advanced education program in one of 6 population FOCI and sit for the certifying exam. They are family, individual across lifespan, adult, gerontology, pediatrics, neonatal, women's health, gender related, and psychiatric mental health. I believe these to be the only areas of expertise in which an APRN can specialize in and therefore can advertise as such per the curriculum standard for nursing schools as developed by the American Association of Colleges of Nurses.
Thank you, Mr. Williams, for your commentary. Any other items or from the public?
No, sir.
Any comments? Any comments from the board? The reason why I moved you up, Van, is I wanted to take up that petition now because I think it's a very important action item for the agenda. And so I think I think we need to address that now before moving forward.
Yes, sir. Ms. Wilton is on the phone as well. And basically, if I say this wrong, I'm sure she will jump in and correct me. Basically, what happened is on the last day of the session, they invoked this older law from right after Katrina, and they had a petition that carried. Basically, it was most of the Republicans, just about all of them, and none of the Democrats. And it basically says that they can end it for 7 days, and they can come back and revisit whether they want to continue the declared emergency. All of our licenses during the volunteer period have been pegged to the health declared emergency. The governor's office has said that he does not believe it took effect until later on. The attorney general's office believes it took effect at the time that it was passed. I think that we as an agency, we're the executive branch of government. And I think what we should do, and Dr. Clark and I have talked about this, is that we should take some initiative and extend those licenses for some period of time to allow the dust to settle and see where this goes and not terminate these immediately until the situation is resolved. But it is, again, the purview of the board. And I'm sure that Dr. Clark would like to get some comments from anybody. He can get them right now and we can talk about it.
Yes, I think, Van and I had this discussion last night, knowing that, an abrupt cease in care would probably cause issues with physicians and patients. But it's not just physicians, there are other licensees that are involved as well. And so I think for protecting the public, I think it would be wise for us to give a specific time. I don't know where this is going, but I think the board, I would ask you to consider potentially a 30-day extension beyond this termination or petition to allow a transition to occur. But I'm more than willing to, I'd like to really get any questions or comments from the board in regard to this, and I would entertain those now. Do I have any hands up? We can open the mics if you
And
wish.
Dr. Taylor has his hand up.
Dr. Taylor.
Yes, sir. Thanks, President. Considering the fact that there's actually a hurricane in the Gulf right now, I think an abrupt cessation would definitely be inappropriate.
Thank you, Dr. Taylor, for your comment. Go ahead. I'm sorry.
And for informational purposes, when that petition was passed, when that petition was passed, was there any type of reference as to what boards were supposed to do with emergency licenses? If not, I would say a minimum of 30 days, and perhaps maybe even the calendar year, just to make sure that any companies or hospitals that have made plans with these people have time to adjust.
Thank you, Dr. Taylor. Any other comments?
Dr. O'Neill has his hand up.
Dr. O'Neill?
Yeah, I agree with Jim. It would be awfully, it would be very difficult for some systems to adjust to this. Ben, do you know if this also affects any of the other components of the emergency declaration, like the telemed stuff? That will take a long time to change, to let people know about that too.
Yes, sir. It would affect everything that's been in the governor's orders and in our rules. If you recall, with regard to the telemedicine issue, there was a kill clause in our rules, and that said during the declared period of emergency, all of those rules for telemedicine were suspended. So when it's undeclared, they suspend. They're gone, and so the rules are back to the old way. Yeah. And just to give everybody a clue about telemedicine in Louisiana, we've issued almost 800 temporary telemedicine permits for people to get care from their providers in different parts of the country because they can't travel readily to them. We see a large number of people who are being seen at MD Anderson for their cancer treatment, and it would adversely affect their ability to continue that. So again, I think that if we recognize that this is an unresolved issue, that we are part of the executive branch of government, and the executive, our governor, has said he does not feel it impacts anything at this time until it's been resolved. I think we are on solid ground to say we're going to go ahead and give a 30-day extension and begin to make people understand what the impact is going to be if this continues.
So you're saying this petition supersedes the president's declaration that's been extended for another 90 days, is what you're saying?
This supersedes the governor. In other words, we are tied to the governor's declaration, not the president's declaration. So because the governor's declaration is in jeopardy because of the petition, basically, according to the law and what the law was written, the governor's petition, the legislative petition ended the governor's declared healthcare emergency period. Wow. However, the governor says no, and the AG says yes, and that's going to be an issue that's got to go to court, I'm sure. And maybe Ms. Wilton will give you more clarity on the legal issues, because I'm just a gynecologist.
A point of personal privilege as president, I'd like Ms. Wilton to speak to this matter for the board, give a better clarification. Ms. Wilton?
Sure. Thank you, Patricia Wilton from the Attorney General's office. So there was information released yesterday afternoon that the governor was going to hold a press conference concerning this. In the end, he did not do it, and I don't really know if perhaps the new weather threat derailed that. But in any event, the latest advisories from the people that are weighing in on this, as Dr. Culotta mentioned, the governor's office is adamant that unless and until he does what the law actually compels him to do, and that is to say, sign an order terminating the emergency, he believes that the mandates are still in place. Of course, my boss, the Attorney General, has stated publicly that in his opinion, the mere signing of the petition, once the ink is dry, that terminates this state of emergency without more and prohibits the governor from calling a new emergency for a period of 7 days. At the end of the 7 days, the governor could take further action or do whatever he wants to do, but he, under the terms of the law, he's precluded from stating a new emergency during the period of that week. There's been some chest thumping by all different stakeholders about whether this is going to court. You know, obviously all of us involved are hopeful that there can be some sort of middle ground between the legislature and the governor to resolve this. In the meantime, my personal opinion is that it was the moving feature of this particular petition was directed at the restrictions that the emergency places, the things that people and businesses cannot do. I don't think anybody actually gave 1 second's thought to the different leniency positions that were enacted as a result of these proclamations, such as suspensions of various rules and laws designed to assist people during the state of the emergency. I'm quite hopeful that someone has brought that to the attention of the people who are negotiating all these things, so that possibly what the governor could do at a minimum is reinstate those things that are lenient, that are designed to assist people, while the measures that restrict personal and business activities can work their way through some other adjudicative process if that becomes necessary. But as Dr. Clark and Dr. Collada have alluded to, certainly this isn't the end of the discussion. I would imagine there'll be further pronouncements today, but it makes no sense at all for this board to proceed to undo everything that's been in place for the past 6 months for a period of 6 or 7 more days while this is thrashed out. So I totally agree with the suggestion of Dr. Clark and Dr. Collada that the board vote to continue these measures in place for whatever period of time you all believe is appropriate.
Thank you, Ms. Wilton. Yes, Dr. Johnson.
I have a quick question for Ms. Wilton.
Please go ahead.
Just for informational purposes, in the middle of an epidemic like this, do we have any opportunities under our own purview to relax rules? Are we under the aegis of the executive branch only during emergency powers from the governor in order to do this, or could we do this on our own? The point of the question would be, as the body who is responsible to some degree for rules during an epidemic, do we have the opportunity to determine when an epidemic is no longer of magnitude to warrant such licensure requirements and that sort of thing? Or are we totally at the mercy of an executive order of the governor?
I'm going to answer your last question with a no, and that is because the board has plenary power, a vast, wide plenary power relative to the regulation of medical licensure. And so it is certainly within your purview as a board to adopt emergency rules for whatever reason you believe is rational and reasonable and necessary for the protection of the public health. The issue, of course, there is that even an emergency rule is a bureaucratic process, and it requires some jumping through hoops. So down the road in the future, if this doesn't, in the immediate future, if this doesn't get resolved to your satisfaction between the legislature and the governor, you certainly can explore the possibility of enacting emergency rules on your own. In the interim, I would say save yourself a little bit of trouble and don't go to that option yet until we see how everything plays out this week. And just use this board action of continuing the exemptions and temporary licenses in place for a period of time. But yes, the short answer to your question is you are free to enact, modify, suspend, or otherwise deal with your own rules as you see fit.
Thank you so much. That's wonderful news. That really gives us, Rod, in my opinion, the opportunity for cake and eat it too. We can do what
Absolutely.
Jim said, and then we can see and monitor what goes on. And if this appears to be an ongoing fight going forward on between the executive branch and the legislative branch, then we can just do our own thing, because we're not going to get in a position where we endanger the amount of health care available in Louisiana during this crisis, for goodness sakes. So that's great news. Thank you.
Well said, Dr. Johnson. Thank you.
Got three hands up. Dr. Thomas is first, then Dr. Valentine, then Dr. Taylor.
All right, Dr. Thomas, you have the floor.
So, Ms. Wilton, forgive me if your previous response answered this question already, but what happens? So we've gotten several complaints from consumers and patients about doctors' offices with various people not wearing masks or with having packed waiting rooms. What happens to those complaints during this 7-day period? What happens to issues where the complaints are specifically regarding the governor's proclamation, and then we're getting complaints about people that have not abided by those things that are covered under the proclamation? What do we do with that during that period of time?
So I would say that any institution or office would have the right to enforce any health-related measures that it believes are reasonable and necessary. Keying it off of the governor's proclamation, which is now in some question as to whether it's effective during these 7 days. As you probably already know, again, my boss has rendered the opinion that those regulations, I think he used the words, are probably unconstitutional, but nonetheless, they have been had the force and effect of law in this state based on the governor's declaration. If I were in charge of something like that, I would take the same attitude that I have suggested that the board may wish to adopt, which is to say, right now, the governor's proclamation is the best medical practice, best scientific, best medical practice that's been declared for the state. And if until a court says that the House petition, in fact, does terminate that as a matter of law, that those restrictions and regulations could continue to be enforced or should continue to be enforced. But again, I think each institution or office has the inherent authority to establish its own safety rules. And if as far as moderating the complaints, I think the institution is in a between a rock and a hard place about people who aren't doing what they're supposed to. And Dr. Collada can tell you himself, the legislature wasn't, the legislature was packing them in like sardines at some of these hearings. So it's a little bit of a hit and miss as to how these things are enforced. There were also concerns about whether the fire marshal actually had the right to enforce any of that and what were the enforcement mechanisms. So I think it's a very long and winding non-answer answer, but procedurally, what should you do with the complaints? I think you should do your best to enforce the health and safety restrictions until they in fact are declared illegal or not able to be, justified under the law. That's my best guess.
Thank you.
Thank you, Ms. Wilton, Dr. Thomas. I think Dr. Valentine is next. Dr. Valentine, you have the floor. Please
Yes,
unmute Dr. Valentine.
Thanks. Can you hear me?
Yes, ma'am.
Okay. Well, hearing this, I guess, along with some of the other comments, I'm concerned about the physicians practicing and the threat of them practicing without a license in our state, and also the patients that they care for. And I guess with the info that Ms. Wilton shared, it may be something to consider, although it would be a lengthy process to start it now, where in the face of a pandemic, we're able to look at the situation and act and extend licensing or lax our processes and procedures in the face of a pandemic. I mean, that may be exactly what we need to do and consider. So then we're staying focused on licensees and patients and Louisianians, just, medically keeping them safe. And, sometimes there may be an emergency that we may identify that doesn't reach our executive authorities, and it's something that we may need to relax our licensing. We see that ourselves and move forward on it. So that's just one thing to consider. And also, it was mentioned, I think by Taylor and O'Neill maybe mentioned the fact that we may want to consider having the 30 days a minimum, because we do have a storm coming, we have holidays coming, we have some time delays that could be built into this, and that way we at least have it covered for a period to really let everyone involved who's making these decisions and looking at the information that they have, the opportunity to come to a resolution.
Thank you, Dr. Valentine.
Thank you.
Dr. Taylor next.
Dr. Taylor?
Yes, just for a point of information, I looked this up to verify. Hurricane season doesn't end until November 30th. So I think we should, of those temporary licenses, with that date in mind as a minimum.
Mr. President,
Yes, sir.
I have heard a suggestion of the extension for 30 days, but I've also heard a suggestion in Dr. Valentine's, if I interpreted it correctly, to begin the process of a new rulemaking that would allow the board to pass a resolution that it determined the issue to be emergency in nature, and then we could have automatic relaxation of rules or how to process temporary permits and temporary issues. And if you want to proceed on, that's not an emergency rule, that would be a formal rule. And we need to get started on that, because with a tailwind and lots of luck, it's going to take 8 months.
Well, I think that's very appropriate. I think we need to get the attorneys on it to see how that, if it doesn't conflict with our emergency rule process that Ms. Wilton articulated, so to make sure that, we don't step on our toes. But I think what Dr. Valentine suggested is very, very appropriate at this time to move forward. Definitely to think about doing. So I would definitely support that. If you want to place that on the agenda in December, I think that we could definitely look into that, and we can have some more discussions before December on this issue. But I understand where Dr. Taylor's coming from. If the board would wish, we could do 30 days. And as president, I do have authority that you've granted me to extend that if necessary, without even having a formal board meeting. And it would be again, I would present that in December if the extension, if I were to, if the board could always go back and say, no, we don't, yes or no, on whether they want to approve what I had done in the interim. But if you want to, I don't know, it's very difficult to say how long. We came across 30 days. It could be 60 days, 90 days, whatever the board wishes. But I think we're all in agreement that an abrupt halt at this time would definitely cause potential harm to patients. And it probably need to make a motion to that effect. But again, I want to leave the floor open for discussion even before we go towards a motion, because I think this is a significant issue that the board needs to discuss. Any other comments from the board?
Yeah,
Dr. O'Neill.
Yeah, hey,
Dr.
guys.
O'Neill.
Yeah, I would suggest we do a 90-day. That way people can make adjustments and try to arrange transfer of patient care. And also with the billing stuff, there's a lot of people that still are seeing people exclusively using telemed around the state. I think you'd be surprised how many of those people are out there. So I think my suggestion would be a 90-day, because that way, most contracts, and most of these people threw together contracts really quick. Most contracts have 90-day out. And so I'm sure they have exclusions when it comes to the emergency declaration, but still, I think we need to be, we all know the virus is still going to be around 3 months from now, guys, right? So
Agreed.
Without getting into the politics, the reality is the virus is going to be around for the next 3 months.
Agreed. Would you like to make a motion? Would that consider that a motion to continue the emergency licensure, temporary licensure that was the board had instituted at the request of our executive branch? Would you want to make that or amend that?
Van, how would I make that broader, where it also includes the telemedicine exception, the billing exceptions, all those?
I would move that we simply state all present emergency licensing and regulatory suspensions and measures be extended for 90 days. And that way you cover everything that's in our rules, everything that's in the governor's declarations, and all the practices we've been operating under.
Okay, so I move that we extend all exceptions and modifications we've made up till now for 90 days to allow notification of people that are impacted by this, that they might be going away, and so planning can begin.
Thank you, Dr. So we have a motion. Do we have a second?
Second, Valentine.
Dr. Valentine is seconded. Any further discussion or any comments from the public?
At Dr. Clark, comment from Jeff Williams again regarding APRN's areas of expertise.
Okay, go ahead, please.
Dear LSB board members, APRN scope of practice issues are uber important to the LMS and all physicians, as it's our #1 legislative issue year after year. Hence, our interest in how the LSBME intends to address this issue as it relates to MPs advertising as surgeons. This individual or individuals is not an employee of the LSBME, nor are they under the purview of the LSBME as a licensee. Therefore, upon request of our attorney, please provide me which exception under RS 44.1 you are using to place this particular item under executive session.
Again, thank you for the comment. Any other discussions on this motion or questions? I think this is such an important motion. I would like to call the roll, Dr. Gullotta, for aye or nay. So, Dr. Gullotta?
Yes, sir.
I'd like to call the roll. We have a motion and a second, and I'd like to call the roll on this, please.
All right, is everybody clear on the motion? Okay,
I'm sorry, Dr. Collada, this is Dr. Thomas. Would you mind restating the motion?
It is my understanding that the motion is to keep in place all of the current exceptions and modifications to our rules and licensing practices and other issues that have been enacted during the period of the COVID emergency under executive order and board rules for a period of 90 days.
That's correct, Ben, this path.
Okay.
All right.
Please call the
Dr.
roll.
Dr. Weather. Dr. Weather. Dr. Johnson.
Yes.
Dr. Horton. Dr. Yu.
Yes.
Dr. Thomas.
Yes.
Dr. Clark.
Yes.
Ms. Sport.
Yes.
Dr. Valentine.
Yes.
Dr. O'Neill.
Yes.
Dr. Taylor.
Yes.
You have 1, 2, 3, 4, 5, 6, 7, 8 yays and 2 abstentions. It passes.
Is okay. All righty. I would like to see if Dr. Weather would like to cast his ballot.
He was-
I don't know if
He
he had
he
a
got
technical
dropped,
issue.
By the way, he's joining again, Dr. Clark.
Well, I like him. If he'd like the opportunity to vote, I'd like him to have that opportunity.
Okay, he's here.
Dr. Weather. Dr. Weather, how you doing, Dr. Weather? I'm sorry we dropped you out on the motion for a 90-day extension of the emergency licensure.
Absolutely.
How-
I agree.
Okay, so there we go. So we have 9 yays with 1 abstention. Motion passes. Okay, at this time, are there any comments from the public?
No, sir.
Okay. Thank you all for taking up this topic today. I think it was very important that we get through that. We're going to go to some promises that were made that on some resolutions that were adopted over the summer that first that we would revisit those, knowing that these resolutions can be changed and they're not rules. And so the first resolution is a resolution of the presidential authority. And that's on page 48 because we went a little out of order. And if there are any amendments or motions that need to be made in regard to this, if not, then we will just leave it. And maybe the next president will consider making it a rule. It will always be a resolution. It can be at any time revisited and whatever needs to be done to it. It can be dismissed, it can be amended or whatever. So, are there any comments on revisiting this resolution? Dr. Yu, I know that you were interested in revisiting this at one time. Do you have any comments? Maybe I hate to put you on the spot, but would you have any comments? All right. I don't know if her mic is muted.
She's open.
Okay. Dr. Yu, would you have any comments or suggestions? Anyone? Anyone? Any other board members? Okay, so no, seeing no.
I do,
Again?
I'm sorry.
All right, Dr. Thomas.
So on page 48, let's see, paragraph 2 and number 3.
Okay.
Let's see, it says here. Okay.
What is that again, Dr. Thomas? I'm sorry.
In number, let's see, I think it's number, wait, let's see. Okay, let's see. Can we scroll up on page 48 a little bit?
You have 2 and 3 on the screen at this time. You have 1, 2, and 3 now.
So it says here. I'm sorry, I'm looking at my notes. There's some.
That's okay, babe. Take your time.
Here. Is there something further up on the page?
It's in the whereases.
There we go. Okay. So in the whereas section there, it says to take certain actions by and on behalf of the board, either unilaterally or subject to, it says either unilaterally or subject to subsequent ratification by the board. But number 3 directly contradicts that because it says any such decisions that constitute an obligation are subject to ratification by the board at the next scheduled meeting. So those two items contradict each other. Is it that they're unilateral or do they have to be ratified? Because number 3 says that it has to be ratified.
Well, I'm going to let Ms. Wilton speak to this, but I can just say the resolves are what really count. But go ahead, Ms. Wilton.
Hi, Patricia Wilton. I think the whereas was a general statement of the necessity to grant the president certain authority to act both unilaterally and on its own. Number 3, Dr. Clark is correct that the whereases don't constitute anything other than a statement of purpose, and it's the resolves that actually grant authority. But I think 3 is specific to obligation, official position, or action of the board. And so, and the R subject language, I think was designed because members were, first of all, Dr. Clark disavowed any wish to be able to go rogue and just do anything he wanted on any subject, anytime, anywhere, and recognized that there were things that it was 100% appropriate for the board to be able to vote up or vote down. But in an emergency situation, it may be that Dr. Clark has to take certain actions or believes he has to take certain action before the next regular or special session. And if any of those constituted an obligation, official position, or action of the board, they would be required to be ratified. I think there are some minor administrative details that he could take that the board would be just as happy that he just do on his own and not have any need of board ratification. So that's, I think that was the attempt that was made in that language.
Great, thank you for the clarification.
Thank y'all both, because we want to get this right. And this is a work in progress, moving towards a potential rule. So this is for the future. So we want to go ahead. I'm sorry.
Just one last suggestion, and if it's redundant, please forgive me. On number 4, do we need to add some language stating as long as there is no violation of the open meetings law?
Ms. Wilton, like I said, I've kind of stayed away from this and allowed the attorneys to really work on this. So I will leave it. Would you like to answer that question?
I can. If that gives you a comfort level, Dr. Thomas, that you believe, that you feel like the board is making clear that nothing in this resolution is intended to violate or authorize the violation of open meetings law, you could certainly include that statement in there. Naturally, as we discussed when this was all being talked about the first time, this was merely meant to continue some of the practices that Dr. Valentine mentioned had been in place when she was president. That was to say that she could, that Dr. Clark could informally speak with members as needed. It's of course implied that nothing he would do would be in the nature of trying to avoid open meetings law or we wouldn't get together any group that would constitute a quorum, et cetera. I don't think there's anything wrong with putting that in number 4 and making it clear, but I also don't think anything in this resolution would ever be able to trump open meetings law. And so open meetings law would always guide and require the president to only communicate in a lawful manner.
Well, if you're comfortable that we don't need to include it, if it would be redundant, then we can just leave it out.
I think that would be best, just for the sake of not necessarily putting language that's not necessary. Certainly, certainly this, as I say, does nothing to abrogate or otherwise encourage or authorize a violation of open meetings law.
And again, we can revisit this at any time. The board member requests that it be revisited and take another look if they want to amend this resolution. So
Sure, and if it's ever,
go ahead.
yes, sir. I apologize, Dr. Clark. And if it's ever formally adopted as a rule, then certainly we could get a little more technical with the language.
Thank you, Ms. Wilton and Dr. Thomas for your comments, for the constructive comments. Thank you so much. Any other comments on this or any motions in regard? Seeing none, we'll just move on. The next topic on the agenda will be another resolution, but it was more of a job position description for our executive director, but there were some amendments that were deferred or items that were deferred that will need to be revisited. I think items, if y'all have it, let's see what page it's on here for you guys. It's on page 50. Does everybody have it? Okay. And so let's talk, if you want, we had approved items 1 through
24.
Yeah, 1 through 24. Is that correct?
Yes, sir. And then
Okay.
previously, item 14 and 15, now the items 25 and 26 were the ones that you asked us to make some information and get some information from the people at Civil Service to make sure that it did not do anything to decrease.
Right. And I think, and then on the recommendation of council, I believe I added with that number C to be brought to the board as well. Seems something that looks like we may have omitted. So I put that also into this. So number C, compensation leave policy will also need to be reviewed. So before we move on to the items that need the votes, 25, 26, and C, do anyone like to revisit what we had already approved in the medical director's job description? Any potential improvements that we could make to this? I'd open the floor up for comments. If not, we will move on to the action item of number 25.
I'd like to move on.
Okay. All right. Anyone else?
Ms. Wilton has her hand up again.
Ms. Wilton?
I just wanted to get in line when we get to subpart C. I have a comment that I might offer for your consideration when you get to subpart C.
Well, any improvements are appreciated, Ms. Wilton. That's what
All
we're
right,
here
well,
for. But we'll wait. Let's wait to get there.
Okay,
though.
perfect.
All right. We don't want to jump ahead.
Yes, sir.
All right. Number 25, page 53. Supervise all accounting and fiscal operations of the LSBME. Ms. Wilton, if you want to comment on that, I think we've sent that up the flagpole to Civil Service. Is that correct?
Yes, sir.
Yes, sir.
And apparently there won't be any issues with Ms. Denise and her duties. Is that correct?
Yes, sir.
Okay. So that was a big concern, and that's what we pulled back on 25 at the time. Is there any issue from any board member, or is there a motion to accept and we can have a discussion, or a motion to deny this item?
Sport moves to accept.
Do I have a second? Second
Weather,
from anyone?
second. Weather.
Dr. Weather. Dr. Weather, thank you. Discussion? Oh, the floor is open. Any hands up, Mr. Allen?
No, sir.
Any comments from the public?
Not at this time.
Okay. All righty. Okay. I don't know. Is somebody trying to speak? I don't know what that is. Okay. All righty. We have a motion and a second. I hear no discussion. Can we mute some of the mics? Because I'm getting a lot of feedback. Okay. All righty. Okay. Is there any hands up, Mr. Allen?
No, sir.
Okay, we have a motion and a second. Hearing no more discussion. Why don't we have Dr. Collada call the roll on this?
All right, on the approval of item 25 as written, Dr. Weather,
Yes.
Dr. Johnson. Dr. Johnson. All right, Dr. Johnson, I guess is not there. Dr. Horton. Dr. Horton. Dr. Yu.
Yes.
Dr. Thomas.
Yes.
Dr. Clark.
Yes.
Ms. Sport.
Yes.
Dr. Valentine.
Yes.
Dr. O'Neill.
Yes.
Dr. Taylor.
Yes.
You have 1, 2, 3, 4, 5, 6, 7, 8 yays and 2 abstentions.
Okay, well, motion passes. Action item is number 26. Supervise the preparation of the LSBME's budget for board review and approval. I think it was probably in the same vein as pretty much the last issue. Ms. Wilton, do you want to speak to that? Any information?
That's exactly the same thing. Previously, there was some concern about Dr. Collada's role in that process overlapping or superseding Ms. Bistinello's, and clearly that was never the intent or desire. And so this merely captures that his role would include some oversight and supervision of that process, but not the actual doing of the work.
Okay. Can I have a motion for approval of 26 or denial?
Sport moves to approve.
Okay, second, please.
You second.
Dr. Yu, any other discussion? Comments from the public?
Not at this time.
Dr. Collada, please call the roll. Dr. Collada?
Item 26 as presented, Dr. Weather.
Yes.
Dr. Johnson. Dr. Johnson. Dr. Horton. Dr. Yu.
Yes.
Dr. Thomas.
Yes.
Dr. Clark.
Yes.
Ms. Sport.
Yes.
Dr. Valentine.
Yes.
Dr. O'Neill.
Yes.
Dr. Taylor. Dr. Taylor.
Yes. Yes.
Mr. President, you have 8 yays and 2 abstentions.
Motion passes. Item C, compensation and leave policy. Ms. Wilton, you said you wanted to speak to this before we get started. You may want to make some adjustments or.
Yes, Dr. Clark, can you scroll it up just the tiniest bit? I mean, Dr. Collada. Okay. Scroll up some more. All right. So everything above the last two, the only operative thing that actually should have been in the actual job description is that second to last paragraph. The executive director shall be on duty and available to serve, etc. Everything above that and everything below that was legal analysis and the support for enacting this provision. And it does reference certain executive orders that naturally will, they're Governor Edwards' executive orders, so naturally those will be replaced after Governor Edwards is no longer a governor. Some of my thoughts and and ideas about the subject don't need to be incorporated in the actual policy. So I would request and suggest that the better way to do this would be for someone to move to take out everything except that second and last paragraph, which is the actual policy and is what should be voted on, and use the remainder of it as for your information and assistance in considering whether you want to adopt this as the policy or not.
Okay, Ms.
I'll
Wilton,
move
thank you. Go
I'll
ahead,
move
Ms.
to do
Ford.
that.
Okay,
So-
basically strike everything except the second and last paragraph of item C is the motion. I'm stating the motion, okay. Second,
Second, Thomas.
Dr. Thomas is seconded. Any discussion or comments from the public?
Not at this time.
I'll give a few minutes for any of the board members. Okay, so the numbers, item C will only read, the executive director shall be on duty and available to serve and in contact with the board at all times, except when on leave. The executive director shall be required to take annual leave only when he or she is not available to perform the duties of office. Okay. Dr. Galata, please call the roll. We have a motion and a second.
On the modified item C, Dr. Weather,
Yes.
Dr. Johnson,
Yes.
Dr. Horton, Dr. Yu,
Yes.
Dr. Thomas,
Yes.
Dr. Clark,
Yes.
Ms. Sport,
Yes.
Dr. Valentine,
Yes.
Dr. O'Neill,
Yes.
Dr. Taylor,
Yes, and Mr. President, I have a point of information request once this is done.
Okay. Go ahead. Go ahead.
Mr.
Dr.
President,
Galata?
you have,
It's not, we haven't, do we need, I think, 1 second, Dr. Taylor, just, are you going to want an amendment to this, sir?
No,
Okay, go ahead, Dr. Galata, then I'll recognize you. Go ahead, Dr. Galata first.
Mr. President, you have 9 yeas and 1 abstention.
Motion passes. Dr. Taylor, you're recognized.
yes, and this is for my own edification. When we have members absent, if they don't vote, is that considered an abstention, or is the vote just not recorded? In other words, if you have 9 members and you have 9 votes, is it 9 yeas, or is it 9 yeas and 1 abstention? In other words, does an abstention require the person to be present and not voting?
I'll ask our counsel to
Dr.
speak to
Taylor, you
that.
read my mind. I had my hand raised to suggest exactly the same thing. If a member has not present at the meeting, then the vote is only yays, nays of the persons actually present.
Okay, so there's no abstentions. Thank you, Dr. Taylor and Ms. Wilton, for that parliamentary advice.
Mr. President, just a point of
Always
clarification.
learning.
Dr. Dr. Johnson is marked as present, but did not vote on a couple of these items, so he would still be an abstention. Dr. Horton has never been present, and she will not be counted.
Is that in accordance with the rules and laws, Ms. Wilton? Is that satisfactory?
Dr. Johnson was not present on those. He was out of the room as well, or he would have voted yes.
That's Dr. Kalata's understanding is correct, and I do believe it is in order for the board to allow Dr. Johnson to amend his vote to vote yay, since he's indicated that.
Dr. Horton has been out the entire meeting thus far.
Do we need to specifically address those items that he was, and so allow him to vote now on those specific issues, not to just say yes on the items that I wasn't here to vote on? Do we need to give him to be more specific, Ms. Wilton?
I think he's indicated his desire to vote yes.
I heard the discussions.
That have
Okay,
passed.
I just want to do everything in the right way, Dr. Johnson. I'm not the
Thank you.
That's all. And if that's satisfactory, it's good enough for me. Okay.
And just so we're on the same page, Ms. Wilton, correct me if I'm wrong. Once the quorum is established, it's present or until there's been a quorum count to change it. Is that correct?
That's correct. Someone would have to suggest the absence of a quorum, and that would require a quorum call at that point.
Thank you, ma'am.
right. If the board wouldn't mind, I'd like to take about a 10-minute break and we can get back together maybe around 10:20. Okay? Little 10-minute break. Thank you. Okay, I hope everyone's back. Dr. Collada, are you here?
Yes, sir, I am.
All right. Hopefully the other board members are back.
Yep.
All righty. Okay, well, hope we enjoyed our little break. The next item on the agenda is page 57, is the position description for the LSBME Compliance Council. This comes from the good works of Dr. Valentine and Dr. Johnson with our legislature and their willingness to work with them and come up with a position that will help us ensure due process. And I hope that this document captures what they delivered to us. And so I would like, before we go and open it up for motions, if Dr. Johnson, Dr. Valentine would like to make any comments before we get started, I would appreciate it. Dr. Valentine, Dr. Thomas, Dr. Johnson, excuse me.
Yeah, thank you so much, Rod, for your work, and Ms. Wilton and whoever, Chrissy, everybody that's been working on this. I think that this is a wonderful first edition, so to speak, and it's really not the first. I know y'all have been working very hard on this, and it seems to come very close from what my expectations were and what I believe the majority of all the legislators and in the various committees had in mind as far as a compliance situation. So I'm real pleased with the process and the way y'all have worked on it and what you have here so far. I'll be glad to hear any other ideas about this, if there's any way to improve it, or if it's not, then we'll go forward.
Dr. Valentine, any comments that you'd like to make?
Just that I agree. I think that this is a great, first kind of, well, I don't know if the last stab at this, getting this position's description correct. Definitely not the first. And I do think it's something that is evolving. We're trying to get it right. We want to make sure that we are actually doing what we said that we were going to do to the legislature. And I think, though, that there may be other opportunities here that we could maximize. And if other board members have any suggestions, knowing what we're trying to really accomplish, and that's making sure the public is protected, and our licensees are protected, that we're protecting everyone's rights and their due process, then I think we're all open to that.
And I want to thank Dr. Valentine and Dr. Johnson for being kind of the tip of the spear on this for us, and all the work they put into doing and taking their time away from their families. So I really appreciate them very much.
Couple of hands raised, Dr. Cresswell and then Ms. Sport.
Okay, Ms. Sport.
Yes, I would like to see included in the position duties something to create an appellate process for complainants who feel that they did not get an appropriate outcome. I think that particularly if they have found new information or feel like the board didn't consider certain information, that we ought to have a process for that. I know that we have a complaint procedure in place for licensees. I can't remember exactly what the rule number or law is, but it's on the bottom of all of our stationery. Someone has a grievance about the way something is handled, but I do think that there ought to be something in here, not just for licensees, but also for the complainants who come forward. That's the first thing. And the other thing that I would hope is that if we do develop a process for the complainants, that we also consider, because of the lack of people who come forward with complaints because they're afraid of retaliation or something like that, that we consider doing something about whether the complainant can receive communications from the respondent.
Okay. I guess maybe I could ask Ms. Wilton. I know who helped them. I don't know if Mary or to help draft this. Would that be within her duties as you see that, Ms. Wilton, as what you've heard the board, you've witnessed the board, and I guess the legislative intent in your mind? If not, then if it is, then maybe Ms. Ford, if you do have specific language that we could potentially add to this, we would consider it. But I'd like to entertain Ms. Wilton first.
Yes, this is Patricia Wilton. I think Ms. Sport's idea about creating a process is a very good one. I actually, my gut reaction is that it actually wouldn't be appropriate to put it in this position description, at least on first blush. I think it's more wrapped up in the whole idea that we're also examining about a way to have a review process to satisfy the legislative auditor. And if Ms. Sport was amenable, we could roll her suggestion into that discussion and make it part of a procedure or a rule versus putting it in this position description. I don't think it would be appropriate to put it in the position description at this time.
Kim, is that okay? Or you, if you want to, I'll accept the motion from you if you want to add something. But if you would...
I don't have a problem with it going into the additional level of review that was asked for by the legislative auditor. And I also want to say that I don't think there's anything legislatively that even mentions our compliance council. We have a rule. But we do not have a statute.
Agreed. But there was, I think the legislative intent was kind of transmitted to us through Dr. Valentine and Dr. Johnson. And that's how the rule came about. And then this is how the job description is being, like Dr. Valentine said, this is an evolution, not, so this is where we are now, not that it can't be modified and or adjusted, but this is something I would hope that we could agree to as a good foundation to begin. And I think, is there any other board members? If not, then I will go to Dr. Cresswell, who's waiting to speak.
Dr. Valentine has her hand up.
Dr. Valentine.
Yes, thank you. I think that Attorney Ford brings up a great idea. I think that it is important that though the complainants that come forward feel that they have a method to appeal a decision. I think that it's also a great idea how she tied it into a person who would be responsible and held accountable for making sure that happens. I think that that's going to be important. So although we're working on that process, and like Dr. Clark said, and I said, this is in evolution, that very well may involve the compliance council. Because just like in this job description, we have developed a desk book, instruction manual, or a similar agency resource concerning investigative due process. We have that, that's something that Dr. Cresswell started working on from day one. And it's just something that the compliance council can work with him on to make sure that we have both of those perspectives involved. But if there is a way to include Attorney Sport's suggestion, if not today, which I would be agreeable to, but definitely in the near future. I think making sure that we specifically state who is to make sure that our complainants are heard is going to be important.
Well, I think Dr. Valentine, we
Valentine.
could go ahead, Dr. Johnson.
Just for my own edification, if I remember correctly, and this was before Kim came on the board, in our original discussions upon this, we talked about an internal appeals process at the end of deliberations at the board level to try to prevent the person who had been complained against having to go potentially into the civil courts with all as a final appeals opportunity, of course, but maybe to be able to handle it internally with another appeals level. And I surely, so for several years now, that has been on the plate to be discussed, and I appreciate Kim bringing that up. I don't know exactly where if that should be in this job description, but it surely should, hopefully, with the auditor and everyone else looking into this, that this is something that we need to try to accomplish.
Dr. Johnson, as president, I promise you that, like I said, I plan to have the auditors, the two potential action items for the board to look at for December. But I think we could definitely incorporate this into that into December, and maybe I can have some discussions with council over the next few weeks until December's meeting, and maybe come up with some ideas for the board to consider which way to go. In other words, putting it into the compliance council's job description, or maybe giving that authority to whatever solution we find for the auditor. So if the board would give me that, I would definitely, that authority, I would definitely pursue that.
Perfect. Thank you so much.
You're welcome. Any other comments? Dr. Cresswell.
I just had a couple questions. One, to address Ms. Sport's concern, I actually agree with you wholeheartedly. I think that's an excellent idea to also get compliance counsel involved with 655 complaints. Just to let you know, right now we do open 655 complaints to complainants and not just for licensees. And so if we do receive a complaint from a complainant where they felt as if the board didn't handle the process properly or didn't listen to things that they stated effectively or thought there was something wrong with the investigative process, we do look at that as a 655 complaint. It's not, we don't look at this solely as a licensee's remedy. So that's currently how we're doing things. But to get compliance counsel involved with that, I think is an excellent idea, and I have no problem with that whatsoever. I did have a question about the position duties, and it was just asking the board for clarification, where it states that handling the yes answers, it says compliance oversight of the investigative process, including handling of yes answers on applications. I just wanted to know exactly what that meant. Did you mean for the compliance counsel to actually take over the yes answers, or to look into that as part of our investigative process and just including that as another investigation, which it actually is?
I think I know what oversight means, but I will let Ms. Wilton answer that question. Patricia?
Yes, thank you, Patricia Wilton. My understanding, Dr. Cresswell, is that it was the latter. It was just merely that she would oversee that to ensure that the handling of the yes answers was also in compliance with due process.
Okay.
Do we need to clarify that, Ms. Wilton? Is there a better way to make it more clear? Do you see ambiguity because Dr. Cresswell brought it up. Is there some particular ambiguity? Could it be stated better?
I don't, but
Okay, well, all right.
as you mentioned, oversight means oversight, but Dr. Cresswell is way smarter than I am. So if he thought there was some doubt in it, I would welcome him to suggest alternate language.
No,
Dr. Cresswell, do you have any?
The only reason I said anything was because it says including handling of the yes answers, and I include that as part of the investigative process. So it was kind of redundant, and so I just wanted to clarify whether or not it was intended as something separate or as part of the investigative process and just being highlighted.
I see exactly. It's the word handling that causes the problem.
Correct.
Is point of information, could we, after the comma, is that necessary? Compliance, oversight of investigative process?
No, you could take it out. You could take it out.
Could you take out including handling of yes answers on applications? Could we delete that?
Based on Dr. Cresswell's reaffirmation to me, and again, I'm still learning, but based on his reaffirmation that yes, answers are routine and customary and part of the investigative process, it is redundant and not necessary. Causes more problems than it solves.
Well, if the board would agree, we would strike after the comma, including handling of yes answers in application. Is there a motion to do that? On the floor?
Oh, move Valentine.
Dr. Valentine moves second.
Sport second.
Ms. Sport second. Any more discussion?
We do have Ms. hand is up.
Okay, Ms. Sport, I think it must be, Ms. Sport, do you have any more
It's on something else after this.
Okay, any comments from the public or from the board?
Not at this time.
Okay, we're going to do a voice vote on this one. All in favor? Okay, go ahead. Okay, Dr. Taylor?
Yeah, I was just wondering, Dr. Cresswell, does that address your concern?
Yes,
Dr.
sir.
Cresswell?
Yes, sir. It does.
Okay.
Mr. President?
Good.
Yes.
Just to be perfectly clear, Ms. Wilton can draft this new sentence in the way you want it. Is that correct?
Yes.
Thank you. We'll make sure it gets done that way if it passes.
Okay. All righty. Any other comments? All righty. All in favor?
I have my hand raised. Okay. I'm sorry.
All right, Dr. Valentine.
A word is missing. It has the third bullet from the bottom. Report directly to the board on a regular
basis.
Yes. Regarding investigations, compliance issues.
Yes.
Report directly to the board on a
Regular basis, it should say. My bad. We'll fix that.
Yeah.
well, okay, that's a friendly
Typo.
amendment. I don't think we'll need any.
Yeah.
Yeah, okay.
Yep.
Thank you, Dr. Valentine. We're voting on striking in second bullet, including handling of yes answers on applications. We have a motion and a second. All in favor say aye. Aye.
Aye.
Aye.
Any dissension? Hearing none. That is excluded from bullet number 2. Okay. As we move through this position and duties, are there any other comments from the board or discussion?
I have a comment.
Yes, Ms. Sport.
It's for Dr. Cresswell, actually. Dr. Cresswell, what, if any, prohibitions do we have on a respondent communicating directly with a complainant during the investigative process?
Usually not advised. I don't think we have any specific written or documented prohibitions. I have had licensees who have wished to reach out directly to the complainant, and some who have on their own reached out to the complainant. Typically, I don't recommend it, but if they want to, there's nothing preventing them.
Okay. I'm thinking particularly in the instances where you may have a physician and a subordinate employee, a physician as the respondent, and then a subordinate employee as the complainant, worried about being fired or having a change of duty or whatever, simply because he or she brought a complaint against someone that has some supervisory authority or is higher in the chain of command at the place where at the place of employment. And I know that there can be a real chilling effect on people coming forward, again, particularly in sexual boundary issues and things like that. And maybe at some point we can consider, as the law is written in the criminal code, something that would prevent communication in certain cases in the future.
Yeah, no, I agree with you. I think that's something that I would support and would be otherwise, a very good thing in certain situations. We have had times where we were concerned about that, especially if we're going to an administrative hearing. We've asked for Judge Bagneris to order that in specific instances during administrative hearings. So we have dealt with that. Also, if a concern like that is ever brought to us in the beginning of the complaint process, we do always let them know that they can remain anonymous up to a certain point as well. And that is clearly explained to the complainant. If we get to the point where we are moving into the adjudicatory phase and the investigation is completed and the respondent has a right to know who their accuser is, then we can then bring it to Judge Bagneris and ask for confidentiality to be issued. If he says no, we can then appeal to the board to ask for confidentiality to be maintained. And at the end of the day, it's ultimately the board's decision.
Okay. I would hate to see for us go through this whole, an entire investigative process, get to an administrative hearing, and then have a complainant / witness who is unwilling to testify for fear of some type of retaliatory action on the part of the respondent or the respondent's employer.
Absolutely. And we've even, for previous cases, asked for video depositions and for video, to be taken that way, so that the person would not have to appear in for the administrative hearing if that was such a very big concern, and it has been in the past.
Okay, thank you very much.
Well, I think that was a lot of order, but I let it go. But I think what we could do, we do have an item on the agenda under future rulemaking. We could maybe bring that up. It's on the agenda. And Ms. Ford, if you'd like to make a motion, we could pursue some rulemaking efforts along those lines. I assume it would take a rulemaking effort to do that. Ms. Wilton, is that correct?
Quite frankly, I'm not really sure what authority this board has to essentially create a civil or criminal penalty for contact. You could issue, you could have rules or guidance, but those types of activities are already illegal. The problem is the board doesn't have any enforcement authority, even if it passes such a rule.
I have a comment.
Got hands up?
Well,
Who's Dr. Thomas is recognized.
And Dr. Valentine.
All righty.
So would witness intimidation be covered under the unprofessional conduct part of the Medical Practice Act?
Exactly what I was
it would
thinking
be.
about.
Yeah, because it's illegal, it would be. But but the board doesn't have any inherent criminal or civil authority, and it would require some sort of adjudication that actually happened before you could take action under the unprofessional conduct clauses of your licensing procedures.
Got it. So maybe if we could just, on the very front end, advise any respondents that we strongly recommend against contacting a complainant. And if you do so, it might fall under the unprofessional conduct part of the Medical Practice Act, and that would save us from the rulemaking and all of that stuff.
But we do actually have that language currently in the unprofessional conduct. And I do strongly recommend that to all of our respondents.
Sounds like we're covered then.
Okay. Dr. Valentine, I think you had a comment, or you're satisfied?
Well, I think what I've heard from Attorney Sport, and please clarify this for me if not, was the fact that there are, criminal kind of implications to retaliating against witnesses, and way that we could, not making it criminal at all for us, but just recognizing the fact, and maybe a little stronger than a suggestion, that it is unprofessional, and that it may be a part of it, but we probably could do a better job of highlighting that. Because when you say you're anonymous up to a point, then there may be instances where you have people in fear of retaliation who say, well, I don't want to take that chance. I don't want to go to that point. But if they know that even after that, there are protections in place, then we may have much more comfort from complainants in speaking up and speaking out. And I think that's important. So it is unprofessional. It's the same way we recuse ourselves from anything that we think we're not able to be objective in. If you're directly involved in a case, you're not objective. So I think that's how I interpreted what Attorney Sport said. And I think that maybe we can have that specifically highlighted in communications to those involved in complaints, even if that accuser is made public, that it is considered unprofessional by their medical board to reach out to that complainant. And if they do, in an effort to discuss their complaints or anything related, that there could be for action against their license. I think that's something, and Ms. Wilton, let me know if that's outside of our purview, but I believe it is.
No, Patricia, I think that's perfectly acceptable to make a more emphatic statement than Dr. Creswell says. He currently emphasizes it, but if you want to make it more emphatic or put it in 14-point bold or whatever, it certainly is within your purview to notify both the respondent and the complainant that there may be board implications as well as civil or criminal implications from such conduct.
Ms. Wilton, would this be more of a policy that Dr. Creswell could work towards instead of us having to vote on anything?
Yes, absolutely. The board could have the board could direct Dr. Creswell to revisit the communications that he currently has and make them stronger and more emphatic in that respect.
So is that the board instructing him, would that require a motion?
No, it could be a sense of the board that you're just telling him.
I think as president, I hear a consensus of the board that that's something that we'd like to see done. And so I think Dr. Creswell, please move towards that. But before we do, I'd like to ask Judge Begnaris what he thinks about this, if he's available to speak to this issue, if he's been on the line.
Yes, I've been.
Judge, I'd like to hear your thoughts.
Well, since basically we adopt the civil code as it relates to our rulings on matters, what I generally do, and it has not been, to my knowledge, has not been tested yet, when I give an order, for instance, if I order the respondent not to communicate with the complainant, with the parties at the complainant, where the board is a complaint, not to talk to any of the parties who are bringing the accusations or their witnesses, unless they do so under a deposition or something of that nature. If that is violated, let's say the party goes and talk to the individual and just disregard my order, then I bring them in under a contempt hearing. I have a contempt hearing pending right now. Now, generally, once the contempt hearing is brought about, the parties, when they believe, whether I have the power to or not, when they believe that they may be imprisoned as a result of the contempt, they generally straighten up and fly right. Now, since I've not had anybody violated twice, I've never had the opportunity to actually cite a 24-hour imprisonment. But it'll be interesting to me to see how that goes. But again, usually when the threat of contempt is there, particularly for attorneys, no attorney likes to be found to be in contempt. And if an attorney did this on behalf of the respondent, I know there's not going to be a problem. But if the individual is not represented, they, I would say, more often than not, will follow the order if they violated it the first time. It will not be a second time.
Judge McNair, thank you for that and educating the board on this. And so I think it's good that we strengthen this because obviously there's a need. But I appreciate Judge McNair's weighing in on this and knowing that he has it covered for us. So I appreciate that, Judge. Any other comments from the public at this time?
No, sir.
Any board members?
Dr.
Anyone like to
raise his hand?
Dr. Cresswell?
I just wanted one more little clarification thing while we're on the compliance council position. Is the board comfortable with the compliance council should at any point she identify an issue, discussing that issue with me in real time where we could possibly mitigate any risk to the board? You know, and so if there was an issue that was identified where it can be corrected and avoid a lawsuit of the agency, I think it's best for the compliance council to be able to have that discussion with me as DOI in a way where we can real time take care of the issue. It wouldn't prevent her from still reporting this to the board and completing all of her duties and things of that nature. But I think communication between the compliance attorney and DOI is key, especially if the goal is to protect the agency. And I just wanted to have the board comment on that, please.
As president, I'd like to weigh in. I think that is totally appropriate. But I think what is totally appropriate is also that the board be notified. And when the board is not in session, that would be the president. In the future, it's going to be someone else besides me. But I think it would be a good idea that if there was a potential breach or a breach that occurred, that you be notified as well as the board. And so I'll let other board members speak to that, but I don't think we should, notifying the board shouldn't wait, 30 days. It should, I think notifying the president of any of those breaches because potentially they could, be very problematic, and let the president at his discretion decide whether he needs to notify the board immediately, the entire board, or it can wait to the next meeting. So I'll open up the floor for any comments.
Mr. President, this is a good question. It goes back to the beginning of the discussions on the Compliance Council, and you've got it exactly right. I think you and Dr. Cresswell both have it exactly right. It's what the original discussions were. Concomitantly, the Compliance Council would notify the board, which would be the president, and of course, Dr. Cresswell, to ameliorate any situation that she saw immediately, but that the board would be concomitantly notified as well of the issue.
Thank you very much for the clarification. I appreciate it.
You're welcome. We're all in trying to make things do the right thing. I mean, this is what this is about. You know, it's about doing the right thing. And I think this has been a solid effort towards that. And it's been a very good effort, in my opinion. Are there any more comments about the Compliance Council job description at this time? I would entertain a motion to approve as amended.
So moved. Thomas?
Dr. Thomas, do I have a second?
Sport second.
Ms. Sport, any other further discussion or comments from the public?
No, sir.
Hearing none. Hearing none. Dr. Collada, please call the roll.
In regard to the amended Compliance Council description, Dr. Weather. Dr. Weather. Dr. Johnson.
Yes.
Yes, Weather.
Thank you, Dr. Weather. Thank you, Dr. Johnson. Dr. Yu.
Yes.
Dr. Johnson, can you tell us if Dr. Horton has returned? Dr.
She has not
Thomas.
returned.
Thank you. Dr. Thomas.
Yes.
Dr. Clark.
Yes.
Ms. Sport.
Yes.
Dr. Valentine.
Yes.
Dr. O'Neill.
Yes.
Dr. Taylor.
Yes.
It is unanimous, Mr. President.
Well, that's wonderful. Thank you all so much. This has been a work in progress, as Dr. Valentine has said. It will continue to be a work in progress. But I think this is a good faith effort moving forward that will hopefully work well for our licensees and for the public. Thank you very much. Okay, moving on. If anyone needs a break, let me know. I know that was a pretty lengthy discussion. If everyone's good, we'll continue. All right, moving on to page 58. It's the organizational chart of the organization that we've tried to put together that accommodates all the laws and rules and opinions, including that of the Attorney General, into one document. And as well as, I guess, the executive director's job description is also included in that. So you can see that a lot of information, even though it looks very simple, it's not. There's been a lot of input and information into creating this organizational chart to make it as simple as possible. But again, hopefully clarifying the exceptions to this structure. So, and that's on page 58. Then on 59, you can see the same structure without the little legend that shows who currently holds those positions within our agency. And so we can go ahead and I'll offer this up to the board. I would like to have Ms. Wilton comment on it because I know she played a large role with me in developing this. Ms. Wilton, do you have any comments?
I think, thank you, Dr. Clark. I think that we heard over the last several meetings, many very valid issues and concerns and attempts to make this organizational chart reflect what the structure of the staff is and should be, as well as keeping the various lines and boundaries that the legislature has put in place adhered to. And this was the outcome of that very thoughtful and collaborative effort.
Dr. Collada, would you make any comments before we move forward? Dr. Collada, do you want to make any comments before we open this up to the board?
I appreciate the comments. I worked diligently with the staff and the attorneys and with Dr. Clark, and to make this reflect exactly what they asked it to reflect. And I hope this makes everyone happy.
Okay.
Dr.
All
Cresswell
right.
has his hand up.
Dr. Cresswell, I will give deference to the board unless there are no questions from board members at this time. Any questions from board members? If not, Dr. Cresswell, you're recognized.
Okay,
My hand was up. I'm sorry.
I'm sorry. Go ahead, Dr. Valentine.
Yep. No, I had my hand. Okay.
Go ahead, Dr. Valentine,
So a couple
please.
of things. I recognize a lot of work went into putting this together. I just want to also make sure that we are addressing Senator Jackson's specific concerns and requests. I think that it's important that, and we all recognize that whoever sits in the seat as executive director, that individual under the board is over the agency. Of course, we're a governing board. We're at the top of the org chart, but the executive director is administratively responsible for the agency. And I think that we can accomplish an organizational chart to really reflect that. I think a couple of things that I noticed with this immediately that specifically go against what Senator Jackson mentioned were the positions of the DOI and the Compliance Council. I think that we would be able to accomplish everything that we have stated we would account for to the legislature as well as what's in the legislature. We can accomplish that by having solid lines for the DOI and Compliance Council, each individually to the board, but a dotted line from the executive director to the DOI and a dotted line from the executive director to the Compliance Council, recognizing that he or she is actually administratively over and responsible for all board activities that happen at 630 Camp Street and then also really beyond that. So I think that we would be able to accomplish specifically Senator Jackson's concerns. Another question that I had was, and our deputy, I see director of IT reporting to the executive director, but the other directors reporting to the deputy director. I don't know. I thought that it had always been that the director of IT was under operations, which would have them under the deputy director. And I don't know if Denise is on. I don't know if she's on, but if she could maybe speak to, I thought that was how that was before. And I'm not sure what changed or if this is it in the right place. Maybe this line is incorrect. I'm just reading it now. So if Denise is on, because she's
may I offer a
she's
point
been
of
there for a
information?
minute.
May I offer a point
Yeah,
of information?
please.
And maybe Vant would I think that what it was the discretion of the executive director that he decided to split some of the duties, knowing that we only have one deputy director and to put everyone under the deputy director. And he decided to split some. I'll let Van to speak to it and Ms. Denise can speak to it if she's available. But if you don't mind, I would allow them to do that now unless you want to continue. But I think that was the reason that was done. Dr. Collada, would you like to speak to that?
Yes, in terms of my initial analysis of the board when I came in, we were woefully inadequate in a number of areas of IT, and we've had a number of projects going on. And in order to facilitate that, actually, while you were president, Dr. Valentine, we moved Alan and the Department of IT under me to make sure we could get things moving without a lot of administrative nightmare. and it's been that way for over 2 years. Additionally, I can take some of this other off, for example, because of we can take Miss Susie and put her under me. But I think that we have our two largest departments, if you will, licensure, which is our largest revenue, and investigations, which is our largest expense, under Deputy Director, Ms. Denise. And then Compliance Council goes there. And we've made a number of comments on the left side with the asterisk to show what you've asked us to, and that there are issues that are directly related to the disciplinary process that are reported to the board, and there are issues that are administrative. And so this reflects an org chart that is administratively bound and in use of the way the civil service. And this is what our org chart used to look like, quite frankly, when you go back and look at the org charts from years past. So again, HR, I'm sorry, go ahead.
Yeah. So, well, when I was president, we didn't have a deputy director. That was created after. So with that, I think that, yes, there are a lot of responsibilities for the deputy director, but ultimately everybody reports under the executive director. So I think that if there isn't, I think that if we have the director of IT specifically broken out, just efficiency, and in creating an org chart, it just isn't how org charts are usually put together. You have a deputy director and when I was president, that person reported to operations. That's IT. Operations, the director of IT reported to the director of operations, excuse me. And so I think that it's important, of course, the executive director will have oversight, but they don't necessarily report to him or her. You will, and if they are the smaller of the departments, that's even more reason to not have them broken out. I think that if you, just as far as equality, there isn't anything specifically that makes a director of IT an individual that reports to the executive director and not fall under the deputy director. Again, this was
an issue to address significant problems that we've done in the past, but more importantly, a division. We can put everybody under Ms. Denise. That won't bother me at least, but I think it is burdensome to Ms. Denise, and I'll take over some of that workload to make it easier for her, because she is the deputy and I am the executive director, and we should split the workload. And that's why we put it that way. But, the board is free to do whatever it wants to do.
Yeah, they don't usually necessarily split workload, as you're saying. And if the deputy needs additional assistance, then that's something that can be addressed. But I know that the director of IT reported to operations. That's IT, it's operations. And so that just, it always made sense. And that's why I was asking Denise, why, if she could speak to some of this change.
Denise, are you available to answer?
I know.
I'm sorry, Dr. Valentine. I just don't know if Denise is available. I'd love her to answer your question.
Yeah, please.
Oh, is she available?
Yeah, she's there. Denise?
Are you muted? We can't hear you. We still can't hear you. Your phone, you may be double muted. Your phone may be muted, Denise. Looks like we're having some IT issues.
My hand is raised in the interim if you
Okay. Is I don't know, Dr. Valentine still has
mine.
the floor. Dr. Valentine still has the floor, but I don't know if she wants to give it up. Would you mind giving up the floor for a moment?
No, absolutely. I want to hear what others have to say, and then maybe we can fix Denise's connection.
Okay. Well, Ms. Sport, go ahead.
I want to clarify that we have obligations as a governing body, and then the executive director has obligations when it comes to administrative matters. I think that, and Christy and I sort of, we discussed this late last night, and we're really in agreement, with the exception that I think that we don't really need to have any lines changed, but that we need more specificity regarding the statutory and rule limitations between the imposed upon certain employees here. So instead of having an asterisk by executive director and then just one asterisk at the bottom, we could actually go straight to the statute, which gives him the administrative authority over hiring and firing, and put that as a number 1. And then for the director investigations, that should be a number 2. Again, including the statute that specifically says that the director investigation should not serve concurrently, as the executive director, and also any other important, just add more specificity to this, and then regarding compliance council, have that footnote number 3 with the rule, our own rule, which gives the definition of compliance council, and maybe, if we think it's important, refer to each other's, refer to any job descriptions that we work so hard on. And I think once that's in there, then anybody that looks at this will see that the DOI and Compliance Council do report directly to the board because of the footnotes and the statutes and the rules that were referred to in the footnotes. And,
Well, just to jump in here, Kim, I think that's why I never wanted lines, because I wanted to strengthen the legend and to make sure that the exceptions were clear. And maybe that's not what we're seeing here is what you're saying, and maybe what Dr. Valentine's saying is we're just not, the legend is not strong enough. But I would entertain a motion if you would like to do that.
I'm sorry,
I would definitely entertain a motion to that effect. And if you'd want to do something like that.
Well, let's hear from Dr. Thomas.
Okay, I'm not at this point, but I'm just telling you I would. Dr. Thomas?
And I will later.
All righty, Dr. Thomas.
I'm just gonna play it straight because I don't know how to wrap this up nicely. But I think what frustrates me about this whole, I'm getting a lot of feedback from something. So I think what's frustrating about this process is that we are creating an organizational chart based off of personalities and who wants to work with who and that sort of thing. I've never seen an organizational chart.
They never heard me. Can you hear me now?
Yes,
Ms. Denise.
Okay, sorry about that. Freddie was in here helping me out.
Denise, can you hold 1 second? Dr. Thomas has the floor. Please hold 1 second. We'll get to you. Dr. Thomas?
I think what's important for us to realize and recognize and stay true to is this organization and not people. Like, we shouldn't even have names of people on here. The organizational chart is to serve this organization and the process and what this organization does. I think this is very convoluted. I'm sorry, I appreciate all the work that has gone into it, but I think it's convoluted and very politically motivated. And I don't think it serves this organization well. I think what we need is a timeless organizational chart that will fit the needs of the board, no matter who is in the different positions. And this thing about sharing workloads and that sort of thing, if you can't do the work that's assigned to the position, then we need to find someone else that can. So I don't know how else to wrap it up, but we're wasting way too much time on this. I don't agree. I'm not voting for this organizational chart. I can't even comprehend, like, to me, like, there should be an investigations department, there should be a legal department, there should be an accounting department, a facilities department, an IT department, and all of those should fit under the executive director. That is typically the way an organizational chart works. There's a human resources department. Human resources falling on these little branches off of the tree. I can't even comprehend what that means. Like, there should be some standardization of all these different departments that fall under the executive director. And then we should go from there. This is just, I can't even begin to process this organizational chart. It's a disorganizational chart in my view. I'm sorry if that hurts anyone's feelings. I'm sorry if you worked on it for a long time. This is an exercise in futility, us sitting here looking at this like this. And we have all of these different players and all of these different people that we're trying to satisfy. What we need to satisfy is the needs of this board, which this does not do.
I want to respond just briefly. Dr. Thomas, and I just want to address the idea about the names. That was put there. Initially, that was not put in the agenda. I want to take personal responsibility for doing that and putting the names with the positions, because I had some board members who I'd spoken to who didn't know who held those positions.
Why is that even important? Who holds the positions?
It wasn't.
Creating an organizational chart.
No, they
for
did not.
People. We're creating an organizational chart for this agency.
Please, may I speak? I picked that purely as on myself and that maybe I shouldn't have included that. It was just more as a point of information, but I apologize if that has upset you in any way in regard to this document. That's totally on me as president. So I apologize to you and the board on that. Who else was next, please? Dr. Collada, go ahead.
I want to say to you that we looked at a number of organizational charts for agencies around the state, and human resources does normally work in the executive right off the executive director. It had previously not done in this agency. We kind of looked at other agencies and looked at how they did their organizational chart. And this is what we learned from looking at them. So we tried to pattern this after other agencies. This was never intended to be about personalities. This was intended to give us something like other agencies. And again, we put this in the names in response to people who didn't know. For example, who's my executive staff officer? That was always Rita, and now it's Ms. Jacinta. We put the names in for people who didn't know about that. So we apologize, but we were acting on the order of the president. We tried to do this in a way that looked like other agencies, and then we put the names in to make sure people knew who was there. It's not about personalities. It's about how other agencies look, and I'm happy to put it any way that you want to make it look, and that's fine with me.
My problem with that is that we need to not just look within what's done in the state. We need to look nationally to see what's done. That's the appropriate way to do this, because who's to say that the way that it's being done in the state is correct? When we as physicians look at studies, we don't just look at the studies that were done in Louisiana. We look at studies that were done in the United States, across the globe. I think it's important for us to consider the way that other states do things and consider best practices whenever we formulate this organizational chart. And again, this organizational chart has to be timeless for this. We are spending a lot of time, and it has to be time well spent. And so we need to create an organizational chart that is timeless for this organization and that serves the best interests of this organization. Otherwise, this is just a waste of time.
Dr. Clark.
Yes, go ahead. Dr.
Just a comment. Number one, I want to thank everybody for all their work. Some of this was created when we went to the legislature, or this effort began when we went to the legislature, and of course, trying to make sure that we were in compliance with what their wishes were for the organization, which of course, in all organizations involves an org chart. So both presidents that I've served under Dr. Valentine and Dr. Clark have worked assiduously on this for the last several years, trying to come up with something that is not personality driven, but organizational centric. And hopefully we're getting closer to that. I certainly understand what some of the other comments are reservations. However, I think that, in visiting with the two presidents recently, it seems that to me, just visiting with them, that we're down mostly now to form rather than any real substance. And what Dr. Valentine and Dr. Thomas and Ms. Ford just talked about as far as the legend goes, the legend itself may be filled out to a greater degree of specificity so that all of and I'm very satisfied with it now, and I like this legend. I really do, or the first edition of it, as to satisfying Senator Jackson and all the rest of the legislators' concerns about separation of the executive power from the investigative division. I think it is wonderful the way it's done. It could be done even maybe more specifically. But the fact that has been done, to me, and listening to the back and forth between Rod and Chrissy on these darn lines, the solid lines, the broken lines and whatnot, if we get the legend totaled out pristine, perhaps we would not need any lines between the executive and, between the investigative division and the compliance council and the board and the executive officer. It would all be spelled out in the English language in the legend, and we could really, have a great document. That's that set of problems. The problems that Dr. Thomas is talking about, as far as just the addition of the deputy director and where those boxes go, and certainly not having names in it other than just for information, as Rod said, goes without saying is the right way of doing that. So that's what my memory of everything is, Rod. I think you're right. You and Chrissy have done a fantastic job along with Vincent on this and council, and we're getting really, really close as far as the substance of what we needed to do. That's my thoughts. Thank you.
And thank you, Dr. Johnson. I know that Ms. Denise has been waiting, and I think Dr. Valentine, would you mind readdressing your question to Ms. Denise?
Yes, thank you. My question was, I know that when I was president, they did not have a deputy director position, and all of these things mean something with civil service. So, I'm glad that we have the position. I'm not at all do I oppose the establishment of a deputy director, but I think that kind of what Dr. Thomas was mentioning and was mentioned by others, we want something that is timeless. IT is operations, and I know that's operations, finance all day long. Why did that change? Why is that not? I mean, that just makes sense to me in my mind that the IT would flow up through operations, and I know that wasn't always the case.
Can y'all hear me?
Getting a lot of background noise, Denise.
That's not from me.
Okay, all righty. Go ahead. I'm sorry. Go ahead.
Let me just talk about the whole history of my job. I was hired in 2015 when Dr. Mouton was executive director. Before I was hired, Dr. Mouton hired SSA consultants to do an assessment of this entire agency before or during the time that we were moving to online licensing system. The result of that assessment was that Dr. Mouton, as executive director, which at the time she was also director of investigations, but the assessment was that she could not be over every department. And so they went to civil service for the creation of my position, which was a director of operations. Not long before I was hired, the accounting manager was terminated. 2 months after I was hired, your CFO quit. So being a brand new employee and coming in and trying to learn about all of your departments, when I was hired, I was over human resources, licensure, accounting, and IT and facilities. Basically finance and operations. Because your CFO quit and you no longer had a manager, my first order of business really was to learn about your accounting department, figure out what was going on in that department, and I essentially became your CFO. And just recently hired, actually this past January, hired another accounting manager to take over those day-to-day duties. A couple of years ago, when we were, well, probably a little over a year or close to 2 years ago, when we were getting ready to go to another licensing system, Dr. Collada and I disagreed on the management of IT. At the time, I'm going to be totally honest, I felt that the IT director needed to be here every day, and Dr. Collada didn't agree. And because we didn't agree, I'm really not the kind of manager that's, I guess, likes to be told how to manage. And so my thing was, if you're not going to let me manage this department, then you're going to manage it. And therefore, IT moved under the executive director. I have never been involved in investigations other than the collection of fines, other than going over the Compliance Council job description. I have never supervised an attorney in the 5 years that I've been here. So this org chart concerns me. It does, because in a way, I feel like in some ways my job is being dismantled, and in some ways I'm being set up for failure, because now I'm being put over divisions that I really and truly don't know everything about. And I guess that's where I stand at this point.
Thank you very much, Denise.
You're welcome.
Dr. Collada, would you like to comment on Denise, since she discussed you directly?
I think that reflects the fact that, we have an IT service that is small and works remotely. I will tell you that there were 2 meetings that Alan coordinated this weekend for the IT. Alan solves problems on nights and weekends from home, as does IT. And the real issue was, do they work from home? And if they're working from home, are they getting the job done? And additionally, there was a number of things that had to be improved in IT. Denise was busy with a number of other things at the time, and I felt it was appropriate to get these things done that I take over. And what we disagreed, we solved the problem by deciding to take over. I would take it over, and she would not have to worry about it or accept any responsibility for that decision. And so, quite frankly, she and I agreed to disagree and move on in an agreeable fashion to operate the agency. Now, having said that, I've worked very closely with a lot of people that supervised by Denise. And I think the issue here is, how do you want this org chart to read? And if you want everybody to report to Denise, that's fine with me. Again,
I'm hearing Denise is uncomfortable with that.
I understand, but quite frankly, Denise's issues with regard to licensing are very much the same as they would be with regard to the issues of the investigation. She's responsible for the administrative personnel issues that go on. Investigations directly reports its investigations issue to the board. It doesn't go through me.
I think the director, the deputy director, definitely should be, taking on a large amount of responsibility. And I'm sure that some of this may be a steep hill of learning, but again, that's what that position was designed to be. So it's going to require, some more work, in my opinion. But regardless, any other questions or concerns from
Well,
the board about the org
That
chart?
was a question, that was in regards to a question that I asked Denise. So if I may, Dr. Clark.
You have the floor, Dr.
That was
Valentine.
thank you. Thank you, Denise, for clarifying that. That was very enlightening for me. So my question is, I know that we've been moving and there was a lot of concern about remote work in the agency. We talked about it when we talked about contracts that came up before. So I guess I'm surprised that we have IT, which is so important and critical, that sounds to be mostly a remote position. When we have everyone, just as that issue happened with Denise and not being able to connect, we had IT, someone from IT right there able to solve that issue, because you need a hands-on IT person. You need IT in the building to solve problems. So I'm surprised by that. I think that if there is a question about how someone or something is managed, that does not automatically equal a change in your org chart and who reports to that person. So I think that if there was a question about the director of IT or anyone in IT being remote, and that resulting in this formation in the org chart, that's a concern, especially when it's around remote work. And I know that there's been a lot of talk around having everyone work in the building. So we want to make sure that everyone is being treated equally. And that, I'm just going to say, sounds exactly like there may be, I could see where someone may have a concern around that. And I'm just going to be very frank and say that I'm getting a lot of, that there's a lot of concern because Zoom, having these meetings on YouTube have anyone watching them. And so if ever there's something that was specifically stated around one member in our agency working remotely, but now we come to find out that the org chart actually changed, because if I'm hearing correctly, Denise wanted her employee to come in, and that was part of the disagreement. If that's what I got from you, Denise, then I could see where there may be the impression that people are not treated equally at Camp Street. I'm just going to leave that there. I think that it is something that we need to possibly discuss more, especially when I think there's something to licensure and being able to supervise licensure with Denise's extensive background and operations. But I think that there's maybe more involvement that she's even hinting at with supervising and being responsible for, professional development or anything like that for a DOI or an attorney. So I think that we need to possibly take a step back and look at this for something that is timeless, not going to personalities, and that we have a way for conflicts to be resolved without our org chart becoming this hybrid of what makes sense and what may not.
Mr. President?
All righty. Go ahead, Dr. Collada. You have the floor.
First, let me say that in IT, we have a total of 4 people. We have a schedule that there's always somebody in the building. We have one of our IT employees whose spouse is deathly ill, and she spends some time with him in his health care. We have one IT who is not very close to the office. They work nights and weekends. And I think that we've got the division of responsibility so that the work gets done. I think the issue here is who can work remotely. And the bigger issue is if we have charts that have to be removed physically, physical charts, I can't let those out of the building because of the issues of security about those charts and the information that is in them. Just like I warned all of us early today that if you've downloaded the agenda, be sure you delete it from your computer. And the issue is security. And we're working very hard to bring up the security every week to make it better. And you're going to get those new computers, and that's going to help us a great deal. I think whether IT is set up to work remotely, the rest of the agency has the opportunity to work remotely as we move into the new system, because that's going to allow all of the information to be electronic. And I think in the future, as we move to that, it's not about personalities, it's about safety of our data, security of our data, and who can work remotely based upon the data and the information in it. As early as 2019, in October, I asked all of the people in licensing to scan in all of the files and get rid of paper files. By the time we got to COVID, they had not done it, and I couldn't let them take their charts out. Our investigations did take some charts out over my objection, but that was given the order, and that's the security issues that I'm very, very concerned about. I think it's important to understand that IT is working day and night around the clock, because sometimes if your email server goes down on Friday night, I'm not going to make them come in when they can work remotely. They're putting in hours on nights and weekends. They work sometimes late at night. They come in very early to make sure when the agency opens, the systems are functioning and with the highest reliability we can. Are there going to be problems? Sure, there are going to be times when things go down in the middle of the day. But whether they're there or not, they're working remotely to solve those problems. So again, I think it's not an issue of personality. It's an issue of capability in each department.
I agree as president. I think this is just, I don't think this is really appropriate to the discussion of what we're trying to do. I mean, we're trying to get an organizational chart together that functions. And the executive director, we've given him that or her that authority to structure the agency and work within the agency. And this is what he and coming with Ms. Wilton and Ms. Mary have come to us with what he feels is the structure of the agency that would work best. And therefore, this is what it is. I think I can accept that. Of course, he and Denise have disagreements, and that's fine, and that's good. But again, he's the executive director, and she works under him. So therefore, if he needs to make the decision, he makes the decision. Someone has to make the decision. And we can agree or disagree with the decision of Dr. Collada, but that's the decision he's been given to make, in my opinion. Ms. Ford has her hand up.
Several people.
Okay.
For a long time.
I would like to recommend that we fix the ledger so that it has more particularity regarding the various statutes, rules, and job descriptions, so that no one can ever look at this org chart and think that it's going around what Senator Jackson has proposed in her legislation, or what we have agreed to in our rules, or what we have agreed to in our job descriptions. Because
are you making that a
obviously
motion, Ms. Ford?
I know
we've been talking about this a long time. It's probably time to make a motion so we can discuss this.
Sorry, I've had my hand raised for quite a while.
That's okay. Dr. Thomas, I think Ms. Ford still has the floor. Go ahead, Ms. Ford.
That is my motion, that we
That
leave
we
the org
accept
chart,
this. Please state your motion, please.
that we leave the org chart as the diagram proposes, but do some work on what's being called the legend, to include the statutes, rules, and job descriptions that have all been approved either by us or the legislature.
We have a motion. Do we have a second?
You second.
Dr. Yu is second. Discussion, Dr. Thomas.
So respectfully, if we're going to require members to use the raise hand function, then we need to follow our rules. I've had my hand raised for quite a while now.
Sorry,
Respectfully,
Dr. Thomas.
excuse me for
Otherwise,
interrupting,
I'll just
Dr.
speak out of
Thomas.
turn like everyone else.
Dr. Thomas, with all due respect, Dr. Taylor, Dr. Valentine, and Dr. Weather and Dr. Yu all had their hand up before you. We can keep track of it on the system.
And
I'm sorry,
mine
Mr.
was up.
President. I'm sorry for. Okay, Dr. Thomas, again, I apologize. We're trying to do the best we can with this technical stuff. Thank you.
If they have had their hand raised first, then they should go first. That's the order of things. If we're going to have.
Okay, would you give up? Would you like to defer and
Yes,
to
I
the
would like to
others?
defer so that we
okay.
can follow the
All
order
right.
that was
Dr.
established.
Collada, who is up, had their hand up next?
Dr. Cresswell has had his hand up, but you agreed
No,
to
no,
take
board members.
Dr. Taylor.
Dr.
Then
Taylor,
Doc-
you have the floor. Dr. Jim?
Thank you. I would like to speak on I don't know that I want to speak on the motion because I think there's some discussion that needs to be had. I certainly understand some of Dr. Thomas's frustration, but I think that frustration comes from the fact that we are responding to outside forces that are political forces in response to behavior by previous staff members. So I don't know that there's any other way to respond to that, but to try and create a org chart that I agree doesn't look like any other org chart. The reason that other agencies don't have org charts that look like this is because we don't have the legislative, for lack of a better word, input that those other boards have. And again, this is for perceived behaviors that the legislature did not care for, and now we are responsible for dealing with it. One of the issues that I had when I saw this, and again, I think this may be an issue of perception, the concerns that we have about the DOI. I think the DOI should be on a higher level on this org chart. I believe that the DOI, in my opinion, should have a closer relationship from a supervisory standpoint to the executive director, provided that we include clear caveats based on not only the revised statutes that address the situation, but the concerns that Senator Jackson and the legislature gave to us at the last meeting we attended at the Capitol. So if there's a way to adjust this, I would like to see the DOI perhaps given a little bit of a higher level in this org chart from a standpoint of understanding the importance of, number one, the investigatory independence, but also number two, the fact that in the end, and everything has to go together for this to be a functioning board.
Dr. Taylor, if you don't mind me, I'd like to just chime in. We do not want to underestimate the importance of the DOI. That's what the discussions that I've had with the attorneys in putting this together is the intent, again, this may be a wrong way to go about it, was to try to put as much distance between those two individuals, in other words. And so that was just another layer of protection for both of from the executive director and the DOI. Is a friendly amendment, if the board wished to move the DOI underneath the director of the executive director, I would not have an issue with it. It was just trying to just add another layer there to accommodate the legislature and what they wanted to do and putting more distance between them. That was the intent. It was not an intent in any way to slight the DOI. I can promise you that was purely the intent. If that's Dr. Collada, I don't think you want to, and Ms. Wilton, would you like to speak to that?
Dr. Collada would just like to say Dr. Valentine is the next board member due to be recognized, then Dr. Weather, and then Dr. Yu, and then Dr. Thomas.
Okay. The comment about putting where the DOI is on the org chart. Do you have any comment about that at all? I had made comment about it.
Yes, I think that having the DOI embedded in the org chart that way, I think is, we've talked to the legislature because we are a legal, and I think that I hear the frustration of other board members, but I think that it's what Dr. Taylor said was correct, that there was concern before. That is why we said we would put, and we had a minority senator say that she wanted the DOI, that's what her intent was in the law, that there would be a separation between the DOI and the executive director. So I think that I'm not certain if even with that, having this org chart, that's legal. I think that the thing that would really follow the law would be exactly what was intended by the law. And we had her on here to tell us her intent was that the DOI reports directly to the board, and then we could put a dotted line between the two of them. I think that's
Dr.
even
Valentine, may I
more-
interrupt if you don't mind? I think we've had the Attorney General chime in. The intent and the law are two different things. And what we have learned, and I'll let you speak to this, but we had learned from Ms. Wilton and others, and Attorney General, is that was not the law, and so we have structured this on what the memo from the Attorney General had recommended. And so and I understand what Senator Jackson had discussed, but I think until the law is changed and made more clear, I think this is what we had presented. You please continue. I'm sorry for the interruption.
Yeah, I think that the problem, though, is that if there isn't any concern with the line and how they're drawn, I think that this part, and please, maybe Ms. Wilton can speak on this. I think the law does state that there has to be the separation, and that's why we had prior org charts developed. I think that, we said to the legislature, and Dr. Johnson specifically said it to the legislature, that we would have the compliance council not having to answer to anybody in the room. I think that we can still have our org chart reflect all of the intent and the law, and have us in a better position, because what we do not want is this to go and have any kind of legislative remedy to what we are not able to agree on here. So if the lawyers can please, Ms. Wilton, I see you went back on mute, but please unmute, because I think that the law actually states that there has to be the separation. Is that correct?
The law states that there has to be separation as to substantive investigative matters. The tightrope that we were trying to walk is that the director of investigations it is within the hierarchy of the staff, such that the executive director is over everybody as a practical matter. The organizational chart, I am happy to agree with anybody, whoever it was that made this suggestion, that the director of investigations could be moved up a level if that's what you wanted to do from an administrative standpoint. And then it would be really flipping what you have now. Right now, you have the director of investigations underneath the deputy director to visually show the separation between him and the executive director in accordance with the law. And then the written notes show that for administrative matters, the DOI is under the executive director. If you flipped it, then you would have the director of investigations as a next level underneath the executive director, along with legal services and the deputy director and IT, or however y'all are going to do IT. That I'm not concerned with that, but he would be on that next level. And then your written explanations would have to state that as far as the substantive investigative matters with the references to the law that Ms. Sport wants, could show. The pictogram is not going to do it for you in the end by itself. You're going to have written explanation one way or the other. So, but to your original question, Dr. Valentine, excuse me, I tend to get too wordy, I apologize. There is a separation in law required as to substantive investigative matters. Absent that, everything else in terms of administrative matters, as we discussed at length in previous board members, the director of investigations is subordinate to the ED in those regards.
I'm sorry, Dr. Clark, can I please speak to this? This is Dr. Clark.
If the other board members who are waiting in line wouldn't mind, but Dr. Questwell, I will have to ask that you wait your turn, unfortunately, until the other board members have a chance. They all have been waiting patiently to speak as well. Who is next, Dr. Kalata?
Dr. Weather, then Dr. Yu, then Dr. Thomas.
Dr. Weather, you have the floor.
All right. Thank you very much.
Unless you would like to defer to Dr. Questwell, but you have the floor.
I would, I'd like, excuse me, I'm very sorry. I would like to defer because I think he's been waiting a considerable period of time. And what he has to say, I'm certain is leading to making things better.
Thank you, Dr. Weather. Dr. Cresswell?
Dr. Weather, I appreciate that.
Sure.
The one thing that I would have to say is this, as it pertains to the Director of Investigations, and my only concern is with that portion. Louisiana Revised Statute 37-1270 states that the Director of Investigations shall serve at the pleasure of the board and be answerable directly to the board, period. The law does not state that the DOI is answerable to the board for investigations only. And as we know that the executive director has no hiring or firing authority over the DOI. So any position of the director of investigations other than answering directly to the board is a violation of the law. And that's it. That is my interpretation. If you can put me under anywhere, it would be a violation of the law if there is not a line that goes directly to the board. And that's the way I view 37-1270 number 9. And I would love for Ms. Wilton or the compliance attorney to tell me whether or not they agree with my interpretation of the law.
Ms. Wilton, would you comment on that statement, please?
Yes, I will. I understand and appreciate the sincerity of Dr. Cresswell's view of the law. Absolutely. I feel as though it may be shared by some members of the board. I just have to say that the chief legal officer of the state, who is the attorney general, has opined to the opposite. And so that's all I need to say. I mean, Dr. Cresswell's interpretation is not the prevailing interpretation of the chief legal officer of the state. And that's not to denigrate anything about what is intended by, as I appreciated, by the org chart, but it is that there are parallel tracks that the DOI operates under in the law and civil service, et cetera. And so it's the substance of investigations. It's the perception that interference in investigations was going on prior to the law. And the law was designed to ensure that that could not happen. But day-to-day operational, budgetary, et cetera, administrative type matters were not carved out of the executive director's customary role in the opinion of the Attorney General.
Thank you, Ms. Wilton. I think Dr. Yu has been holding. Dr. Yu?
Hello. Yeah.
I'm sorry, Dr. Yu, for holding so long.
That's fine. That's fine. Now, most of my concerns actually were brought up by a number of the board members. But I do want to say, I agree with Dr. Thomas that if one were to do this, one could certainly refer to some national information. However, like all of us know, one has to modify it accordingly to the state. And we have some uniqueness here in Louisiana. And I think that's what we're trying to do. One of the other things I wanted to bring up is there a need to define what the deputy director is? Because it seems like the job of the deputy director, there seems to be some questions regarding this. Is there some paperwork or whatever that describes it? So that's my question. The other thing that I want to refer to regarding the legend, I think we're making ourselves a little bit too redundant. We have already defined the director of investigations responsibility and so forth. Why can't we just make in the legend refer to the statute or policy or whatever that we've done in regard, as well as with the ED job? Why can't we just write refer to? Because that means all the descriptions, all the details are in that policy. Instead of
that's a good point, Dr. Yu. That's a very good point.
Right, yeah. Instead of describing one sentence, two sentence. And I also agree with, and I can't remember who said this, but I think the DOI position needs to go up.
Okay.
Yeah.
Okay.
Those are my points.
Thank you so much for your points there. And who is next on the list, Dr. Collado?
That would be Dr. Thomas and then Ms. Bushnell.
Okay, Dr. Thomas.
Have we done any, I tried to look over the weekend, but couldn't find anything. Have we done, two questions, have we done any research as to best board practices from the FSMB? And then secondly, I noticed that Denise said that back when Dr. Mouton was executive director, she had SSA do some consulting work on the board organizational chart. Have we thought about perhaps getting a consultant firm to consult us on what are best practices in terms of board organization, like nationwide, not just appropriate here in Louisiana?
Dr. Collado?
We certainly looked at the SSA report that was present, and we utilized that as we developed this. We did look at the FSMB, and they're basically, the only thing I could find was their, if you recall, I think you and I both attended the same presentation about the differences between organization, operations and organizations governance. But other than that, there's no thing about organizational charts, except to say that there should be a clear division between governance and organization and operations. And I think clearly we can get another consultant in here. We can take this back. We can do anything you want with it. We just need to get this done. And in response to what Dr. Yu said, we have no formal job description presently for Denise. We have no formal job description presently for the Director of Investigations. We can certainly put those together and bring these back at the same time if you want to do this. But again, the agenda that was set for me was to do it this way, and I'm happy to do it any way the board directs me to do it.
Thank you, Dr. Collado. Denise? Ms. Bushnell?
I actually just forgot to put my hand down. I didn't have anything else.
Thank you so much.
Okay.
Okay, so this is where we are. We have a motion and in a second to accept as written and to make accommodations to the legends to strengthen them as per Ms. Sport. I recall Dr. Taylor brought up a potential motion, an amendment to move the DOI up the org chart underneath the executive director. Dr. Taylor, is that, or you want to make a motion to that effect?
Well, if Ms. Ford will accept that as a friendly amendment, we can go with hers.
Okay, I think that is a friendly amendment. I don't think unless we need to, I think in this case, I think we probably need to vote on it. Probably in this case. Do I have a second on Dr. Taylor's motion to move the DOI in the org chart underneath the executive director? Do I have a second?
O'Neill so moved.
Dr. O'Neill has moved. Any more discussion? I think we've discussed this to death. Call the roll, Dr. Collada. Dr. Collada?
Yes, sir. Dr. Weather, on the motion to amend, to increase, to raise the level of the DOI directly under the Director of Investigations. How do you vote, Dr. Weather?
Yes.
Dr. Johnson? Dr. Johnson? Dr. Horton?
Wait a minute. Are we unmuted?
You're unmuted now, sir.
Okay. Tell me again what this motion is for, to put somebody directly under you?
Is to move the Director of Investigations up one level under the Executive Director.
Yes.
Dr. Horton?
No.
Dr. Yu?
Yes.
Dr. Thomas?
No.
Dr. Clark?
Yes.
Ms. Sport? Ms. Sport, you're muted.
Yes.
Dr. Valentine?
No.
Dr. O'Neill?
Yes.
Dr. Taylor?
Yes.
Dr. Taylor, was
Okay.
that a yes? I could not hear it. Was that a yes, Dr. Taylor?
It's
Did
my
any-
motion.
It was his motion, so he's voted yes for his motion. You never know.
All right, you have 7 yeas and 3 nays. The motion passes to amend the proposed org chart to raise the Director of Investigations under
Okay.
the Executive Director.
The current motion on the floor now is Ms. Sport's motion to accept the org chart as amended with additional clarification to come at the next board meeting in the legend. Is that correct, Ms. Sport? I don't want to misstate your motion.
That is correct.
Okay. And why don't you go ahead and call the roll?
On the full motion as amended, Dr. Weather,
No.
Okay, I'm so sorry. I was trying to get on here to have a little more discussion. There's been, I love Dr. Yu's recommendation. I don't know where Kim stands on that as to how to build out or to in any way accentuate the legend so that everybody could hopefully,
Right.
there's no way this could be easy. I mean, this goes back, I mean, every day of the world, we're looking at the Federalist Papers as to how the Constitution was evolved from that in the Supreme Court. So my God, this, I do understand the intent and whatnot of the legislature needing to be looked into in great depth and whatnot, and vis-a-vis the legal opinions and whatnot. But I don't know what the legend, I need to know a little bit more about what Kim's motion will really mean before I think I can vote on whether or not the entire document looks good enough, because I think it's going to involve quite a bit. Is it not, Kim?
No,
No?
Well,
Okay.
Lester, what I would want to do is what I hear Kim's motion to be is that we would approve as amended, and then we would come back to the board with another vote on the legends. In other words, we're just not going to accept it without review. I wouldn't put that the board do that. That we would come back and address this item again. Is that right? Would you agree with that, Ms. Sport? I think I wouldn't blindly want you to approve
Yes,
something
and-
without review.
And someone else, I don't know if it was Dr.
And
Lewis.
with Dr. You as
You
well,
said-
and putting in her thoughts in getting the legend better organized or and maybe more succinct. That's kind of what I'm thinking.
Succinct sounds great. If we just put C, board rule, XV, III, or C, Louisiana statute, whatever the statute is, that probably would be enough.
Is that okay, Lester?
I'm fine.
So we're now voting again. Okay, let me just get this straight. We're voting on the boxes and the lines up there right now that has been already amended.
Correct.
To get the DOI in a different position that everybody was, or at least that got through.
That was amended.
Now
Now
we're
we're
having
voting on
nothing
the
to
org
do
chart.
with the legend will be, of course, part of this in the end, and it will be voted on at a subsequent time. Is that where we
Yes,
are?
I plan to bring it back in December.
All right, yes.
Okay.
Okay, I'm sorry. I did never hear Dr. Weathers' vote, but I have Dr. Johnson's.
Dr. Weather, could you please repeat your vote?
No.
No for Dr. Weather.
Dr. Horton,
Yes.
Dr. Yu,
Yes.
Dr. Thomas.
No.
I'm sorry, ma'am.
No.
Thank you, ma'am. Dr. Clark,
Yes.
Ms. Sport,
Yes.
Dr. Valentine,
No.
Dr. O'Neill,
Yes.
Dr. Taylor.
Yes.
The motion carries 7 yeas and 3 nays.
Okay. Thank you all very much. I think what we'll do now, looking at the clock, it is 12:09. We can do 45 minutes for lunch and say 40 minutes. And so we'll be back here at probably around 1:50-ish. Okay, take a break. Dr. Collada,
Yes, sir. Here I am.
are we ready to get started?
I'm ready if you're ready.
All right. It's now 12:52. And I think the next up is financial report.
It should already be available to you on your share screen.
Okay, is Ms. Denise ready to present?
I sure hope so.
Danny's on the call to present, actually.
Danny, how you doing?
I'm
Danny?
good. Can you hear me okay?
I can hear you. How you been?
I've been all right, but hanging in there like everybody else, kind of working.
Through the
remotely
hurricanes and the COVID, huh?
Yeah, and the economy and everything else that's going on these days.
God bless you. Well, I hope we have our quorum is back. I don't know if Ben, can you tell if everybody's on? I don't want to start unless we have the majority of the board members on. I hate to call a roll, but we may have to. I don't want to slight any member. Dr. Collada?
I can't tell you exactly who's on right now, but Dr. O'Neill, I see his camera and it's muted.
You muted yourself.
Most people don't have a picture up. Dr.
Okay.
Taylor's on board, Dr. O'Neill is on board, Dr. Weather is on board. But after
Okay.
that, I can't tell.
Call the roll, please.
Roll call. Dr. Weather. Dr. Weather, right? You here?
Yes. Yeah. Here.
Dr. Johnson,
Here.
Dr. Horton,
I'm here.
Dr. Yu,
Here.
Dr. Thomas,
Here.
Dr. Clark,
Here.
Ms. Sport,
Here.
Dr. Valentine, Dr. Valentine, Dr. O'Neill,
Here.
Dr. Taylor,
Here.
Dr.
Okay.
Valentine. Okay, you got everybody here but Dr. Valentine.
Well,
I'm
let's
here.
proceed.
I was on mute,
Oh, Dr.
actually.
All right, Doctor. All right.
Yeah,
Dr.
thanks.
Valentine, thank
I'm
you.
actually here.
All right.
Thanks for
Okay,
waiting.
Danny, go ahead.
All right, good. Well, we're looking at the bank balances per month since January 2020 for each of the different bank accounts LSBME has. And I guess the thing to note is that in the last few months, the bank account balance has gone down, which is expected because of the extra cost that's being paid for the building renovations. To date, I think we spent through August, around $600,000 of building remodeling. And, another reason for the decrease in the balances is related to the operation expenses that were questioned on last month's meeting, which Denise provided explanations for subsequent to that meeting, and that still holds true. Any questions on the bank balances?
Please open up the mics. We're not going to use the raise hand function. If there's any questions from any board members, please allow them to speak freely.
Okay, I'll go on to the
Hearing
next
none,
page.
go on, Danny, go on.
I'm sorry.
Okay.
Could we see a copy of the budget on the screen, or am I doing something wrong?
The bank balances are on the screen is what you were talking about. Did you want to talk about another item right now?
No, I may be doing something wrong. Is the financial information posted on screen?
Currently,
Yeah.
it's the bank balances is
Got it.
what's
Okay.
posted right now. There's
Thank
other
you.
slides to come. Danny, proceed.
Okay, let's go on to the next page then, which is the collections for the PHP and the CME program. Nothing unusual there. It's pretty much, right around the same amount of money each month. It fluctuates a little bit here and there, but it's all within the same ballpark. All right, let's go to the next page.
I think, wait, before we move on, I want to ask if any of the board members would like to comment on that.
Okay.
Just take our time. This is our
Dr. Taylor.
financial stuff.
Dr. Taylor has.
Sure.
Dr. Taylor?
Yes, thank you. On the collections and payments, I see PHP and CME is the, as the LLA told us that we needed to be more strict about collecting fines. Is that part of this, or where do we see that number?
So the fines are going to be on another page. That's going to be separate from the PHP.
Okay.
And the
Okay. Proceed, Danny.
Separate from fines. Okay, thank you.
Yeah, this is just the part of the fees that come in for the PHP program and the CME program. Yeah, you can go to the next page. All right, so this is the revenue
Income statement, yeah.
statement for the past 4 years through the months of August.
So I have a
Why don't
question.
you just walk us through that, Danny? Oh, I'm sorry, Dr. Thomas, to ask your question. I apologize. I didn't mean to trip over you.
That's okay. I see, so under that second line, penalties, fines, and fees, that's quite an increase. Do we know why that increased so much this year?
Yes, the reason is because during the audit we had a year before, it was noted that we weren't necessarily collecting the fines and the fees as we should have as is required. So beginning in 2020, those fines and fees penalties and fines were being collected again.
Got
Dr.
it.
Thomas, that also includes the fingerprint fees that we talked about last month.
Okay, I appreciate that. One question that I had about that was, and if this is out of order, or if it needs to go in a separate place for discussion, do we need to make any consideration for any physicians that may have trouble meeting their yearly licensure fees?
Oh, like uncollectibles? I mean, fees that have not been paid?
No. I guess this is just a general question for the president or for the executive director. Have there been any requests from licensees to waive their licensure fees, or is there anything that we need to consider to help our licensees out during the pandemic?
I think that's probably a question for Dr. Van or Dr. Clark. We don't, as far as I know, we don't waive fees. We have waived late fees during COVID, and we've waived late fees when our system was down. But as far as waiving license fees in general, I'm not aware of anything like that.
Yes, it was.
Dr. Thomas?
Uh-huh.
I have the authority under the Emergency Powers Act that were granted under these declarations by the governor to do something like that, but I have actually not received a single request to do so.
Okay.
Everybody has expressed appreciation on the CME waiver, but in terms of fees, nobody has asked me to do it. I think we could do a number of things. What I would do is set somebody up on a time payment plan or something like that, and we would help them out any way we could. But at this point in time, nobody has made that request to me. If the licensing is getting them, they have not communicated it to me.
Okay, thank you.
Thank you, Dr. Thomas. That's an important question. I'm surprised we haven't had more folks ask for that. It's been pretty rough on a lot of doctors. Okay, Danny, continue.
All right, so revenue was moving in an upward trend. It's $300,000, $370,000 higher for the year 2020 for the first 8 months compared to the year before. So that's a pretty good increase in revenues, primarily coming from the fees, the fees and the fines, penalties, fees and fines are up a couple $100,000, which accounts for most of that. The rest is just general increases in revenue. And then on the expense section, those are pretty much in line with each other. The only thing that's kind of a little bit more than it has been in the past, which is, salaries and wages and employee benefits, which are tied into each other, just because of the increase in the number of employees and payroll costs that we've had. The operating costs are higher this year, as explained in the email that Denise sent out, primarily because we're paying for our own fingerprinting expenses now. That's an expense we didn't have in the past, but that's offset by the fees that we're collecting at the top. Credit card fees are up a little bit.
Danny, this is Clark. I have a question. So we weren't paying a cost to the state police for that? For the fingerprinting?
The applicants were paying state police directly previously.
Okay, so we've absorbed that cost? Is that what you're saying?
No, sir. They pay us, and now we pay state police monthly.
So there shouldn't be an increased cost,
Well,
in other words.
the cost is increased because you didn't have this cost at all before on the books. There's increased cost, but there's also revenue that covers
Revenue
that
that
cost.
offsets the cost.
Correct.
So, okay, all right. Thank you for that clarification.
You're welcome.
And then the security costs, are up higher because we have security on site every day now that we didn't have in the past. Those are the main things that have increased the operating costs. But still, if you look at the total expenses section, overall, the total expenses are still down compared to the prior year.
Well, there's no hotel costs, right?
No, the travel costs. Yeah, no hotel costs, travel expenses.
Travel expenses are way down.
Way down.
Oh,
That's
gosh.
correct.
All right.
Of course,
the
the legal and investigative fees are down substantially, but that's going to change because I think the contract with Adams and Reese was approved in September, and so that expense will hit the books in September.
Okay.
Well, we actually paid Adams and Reese, and we won't be using them the remainder of the year. So that's actually going to stay down for the rest of the year.
So has it hit the books yet, though, Denise? That's what Danny was saying.
I think we actually paid them in October, I want to say, September or October. So it'll show up the next time we present.
That's what Danny was saying. It'll show as a cost.
Right.
Okay. Okay. All right.
Any questions on this report?
The income statement.
The only thing, Mr. President, I want to make sure it's clear. The contract was approved to retroactively pay for the work they did in this year. The contract overall is not renewed, and we are in the process of presenting to you, hopefully at the December meeting, some other alternative attorneys to present to be our outside counsel.
Yeah, I think that's going to be, we're going to present that, but I think that's going to be an ongoing discussion. We won't be making any final decisions in December on that unless the board just says, oh yeah, we like this. This is great. I think that's going to be something we'll be discussing. I know we're a little off topic during the financial statement, but just to reassure the board, we're going to just bring some potential ideas and or firms to the board for discussion. And you're going to discuss that with your staff too, especially Dr. Cresswell, and make sure everyone's in the loop, right, Dr. Kalana?
That is correct.
Thank you. Danny, continue, please.
Yeah, just was asking if there's anybody had any questions on the numbers on this report, the income statement.
Any questions from the board or comments from the public?
No comments from public.
Okay, then the next page is going to be the income statement for the clinical lab.
It looked like Dr. Taylor has a question. He's waving his hand.
Oh, okay.
Dr. Taylor.
Yeah, I see him.
Yeah, my hand's up. I have a question about CLPC too, so hold that for a second. I would ask if it's possible for the next statement, the one in December. I don't think we need to do this every month, but I'd like to see an end of year total of just the fines. This is
I understand.
Something that we changed in response to the legislative audit. I'd like to see if we've done a better job of that, which it looks like we have. But again, we have some fingerprint fees that are mixed in there, so it's hard to really tell. And secondly, for those physicians who have a perception that we find everybody so that we can fund our operations, I want to tell them what that number is and how small it is compared to the 5 million, so they can stop telling us that.
Denise, why don't you give
Okay.
us a little sneak peek of what's going to be in December? December.
I
usually when
think
you
December is fine. I don't want.
Yeah, well, December we present our
But I think
budget.
at the end of the year, we should know that.
She presents the budget primarily for the following year.
Right.
But
I present the budget in December, and we typically don't present year-end numbers until February because we don't pay December bills till January. So it takes us a while to have year-end numbers. But I
is
can
that
tell
okay,
you,
Doctor?
go ahead.
I was just asking if that was okay with Dr. Taylor. If not, we could probably.
Yeah,
give
that's
you
fine. Whatever the
some
appropriate time
preliminary
is to do
numbers.
that year-end assessment.
Yeah,
Yeah,
whatever
whatever is the appropriate time to do that year-end assessment. I'd like to break that out separately so that we can show that we're responsive to the audit.
Okay, and we can still give you a breakdown of that the next time we present in December. We'd be
Let's do that.
presenting through September. I think we've only collected like $30,000 in fines, but I could give you a more accurate number next month in December.
Okay, and maybe some year-to-year comparisons so that we can show whether in fact we are doing better than we did in the past.
We're going to make
Sure.
that as an item on the agenda for next time. How about
Okay.
that? Thank you.
All right, and while I got you, I have a CLPC question.
Go ahead, Jim.
Under contracted service, I see there's no salaries and wages. Does that mean the executive director of the CLPC, she's paid as a contract service?
Correct. She's paid through contracts. We do have employees that are paid salaries, but what we do with clinical lab, because those employees work here, the bills are paid here. I do a year-end allocation of costs to clinical lab, so those costs don't go on their books until the end of the year.
Okay.
Is that okay, Doc? Does that answer your
Yes.
question? All right. Denise, thank you.
You're welcome.
Danny, are you done?
I think that's it, unless anybody else has any more questions.
Any questions from anyone? If not, we'll need a financial report. We'll need a motion to accept the financial report.
So moved, O'Neill.
Dr. O'Neill, second.
Second, Thomas.
Dr. Thomas, any other discussion? Any other comments from the public?
No, sir.
I will do a voice vote on this. All in favor, say aye. 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 All against, say nay. Hearing no nays is approved. The next item on the agenda is future meeting dates. The next meeting will be in December. And anybody have any conflict with the 2021 proposed meeting dates, let us know and see if we can make some accommodations. Just call me or Van or I, excuse me. And we'll make those accommodations for the board. I don't see the FSMB, is that going to be virtual in April? We don't know, huh? Okay. Seeing no comments on that, let's move down to the regulatory report.
I think
And
Dr. Collada was speaking to that, but we just couldn't hear him.
Really? He was yapping? You can see his lips moving. He's on mute. Van? I need to text him.
Your lips are still moving. We can't hear you.
I'm going to text him and tell him he's...
I unmuted myself. I hope you can hear me now.
There you go.
Can you hear me now?
I don't know. Apparently you're going a mile a minute. Dr. Valentine saw you talking, but no one
Well,
could hear
thank
what
you.
you said.
I'm not sure what my computer was doing. I'm pushing the buttons, but it's not unmuting me anyway.
Stop
Let me
pushing
say
the
to you,
buttons.
yeah, stop pushing the buttons. At any rate, we did talk, my little administrative group is talking about the fact that it probably will be virtual again because it doesn't look like they'll have time to prepare another in-person meeting because of the uncertainty of COVID and whether or not the vaccine will be here and all of those things. So it looks like it's presently going to be virtual at this time. Likewise, I think many of our earlier meetings in the year coming up will be virtual. But as soon as we can meet without social distancing, because if we meet with social distancing and we have a full board meeting, a couple of y'all are going to be sitting on the, not on the dais, because I can't separate you 6 feet apart. So again, I think that that's what we're doing right now, and I would continue to do this by virtual meeting at this time.
Thank you, Dr. Van. Now it's the combined regulatory report, and I don't know if Mary usually presents that, Van, but I guess you need to, or Ms. Wilton.
Let me get to it, and I'll take a stab at it.
Hey,
I don't
Van,
think there was anything under that. It's now that I remember, it's looks like it's empty. I'm sorry. Rules under development. This is
Van, real quick, the question. This is O'Neill.
Uh-huh.
So if indeed the legislation canceling the executive order, or the emergency order goes through, can we still hold virtual meetings?
That's a good question.
Okay, it would be my interpretation based upon what we heard from Ms. Wilton, that we would honor as a part of it, the executive branch of government, the orders of the governor, unless the governor tells us otherwise. The wrangling that will have to go on is going to have to be in the courts and not with us. And I think we would continue to operate under those rules until such time that there is a change from the governor telling us not to. And we'll go from there.
We probably needed some legal advice on that, Van. But it seemed that would be the proper thing to do. It would be to continue doing these virtual meetings.
It's not so much about proper anymore. Can't you tell?
Okay.
I didn't mean to say that.
That's okay.
Okay.
It's
No, that's
okay.
okay. It's
Right.
okay. It's okay. I just say okay. All right. We're in the rules under development.
All right, I want to make sure you can hear me.
Go ahead.
The assessment of costs. So this has been submitted to the FEIS for its review. It was approved with minimal changes. We've sent it on to the register for October publication. And if there's a hearing, it will occur on November 24th. Remember that you all agreed with the interpretation of council at the time. We do not have to have the board to have the hearing. Mary and I will have the hearing and present a transcript at the next board meeting of any comments that were made. And so we would have that hearing in November. The petition to make rules, again, is in the same posture. It was submitted to FEIS. They've approved it. It's been submitted to the register. And again, we would have that hearing on the same day, on the 24th. The physician licensure, IMG issue, is in process. Again, if you go to the next page, it's been submitted to the fiscal office. And if there's a hearing, if any, it would be on the 24th. The physician licensure.
So what is there any hangups with that, Van, at all?
At this point in time, no, there's no hangups at all. We're planning to
From our
have that
side,
hearing.
I mean, from our side, there's no, and Dr. Taylor, have you heard any issues with this at all?
None whatsoever.
Okay, all right.
Let's keep
Go
it
ahead.
that way.
Well,
Okay.
I just potentially maybe heard that there was some unhappiness at the legislature about some of this, and I just not specific, but I didn't know if we were following our process. I thought we were moving along. So if there's something that's out there, please let me know. And Dr. Collada know, because I think it's in the mill is what I hear, right, Van? It's in the mill.
It's in the mill. We're following the process, and we will be following and having the hearing. I mean, if anybody knows of any issues, I would appreciate you letting me know so that I can work with the appropriate people to make sure they can process, send something in person or up here. We're going to set this up to be virtual again. Or we can do this in person because it's only going to be a small number of people at the dais. And if people want to submit in writing, they can submit their comments in writing and their deadlines for those various things. All right, so the CME issue and licensure is, again, it's been submitted. It was approved with minimal changes. And we've submitted it for the register, and we'll have the hearing again on November. We'll be full of hearings that day, so I won't have to worry about it. The podiatry doing history and physicals is in process again in the same posture. Hearing due after the publication in October on November 24th. And we haven't heard a lot of problems about that. I know that the podiatrists are waiting for it. We haven't heard anything from anybody else. Complaints and investigations, that will also be in the same posture. It will be heard, if any hearing will be on the 24th. And it's been submitted. The fiscal office had minimal changes, as they always do. And we're there. The emergency temporary permit has been done. And some of this is going to be formal changes to our rules to help expedite the emergency and temporary permits in the future. But again, at this point in time, they have a hearing on November 24th, and we'll see what happens. And then the waiver of qualifications. This is the issue that we granted some exceptions to at the last meeting. And we will provide a copy of the public comments and any materials that occur. Again, it's on the 24th. The FEIS has been approved. And again, after these go through the hearing, we have to review it, make any changes that we think are necessary on these rules, and then resubmit them to the Occupational Licensing Review Committee. If they approve them as we resubmit them, then it's final notification. And once we we send it to the legislature, and then they have 35 days from final notification to having a legislative oversight hearing. So that's where we are on the rules.
Any questions from the board? Any comments from the public?
Alan, have you gotten any? I think Mr. Williams has been sending some emails that were popping up as I was handling the presentation.
Yeah, he had sent one. He said, I know we're on a delay, so be advised I'm going to send a comment right before they adjourn to the public session. I guess making sure we're.
Okay, is there a comment there?
He just sent another email about the APRNs.
Well, can you read it for me? Let's go ahead, because I think that's the third one he sent. We may have to have Ms. Wilton address this. Go ahead. What is this?
Yeah, it's on behalf of the Louisiana State Society. I respectfully request an official response to my prior inquiry before you adjourn the public portion of your meeting, e.g. the nurse practitioner advertised on Facebook as an NP surgeon. Given that, 1, this incident occurred publicly on Facebook, 2, the individual is not an employee of the LSBME, and 3, APRNs are not under the purview of the LSBME as licensees. We, upon request of our attorney, would like to know which exemption under RS 44.1 are you using to place this particular item into the executive session portion of your meeting. The topic of NPs inappropriately holding themselves out as a particular specialty and how the LSBME plans to deal with that issue seems like a public issue.
Ms. Wilton, I think this is very prickly, and I think I need you to handle this because this is an executive session matter. We voted on that earlier in the meeting. So if you could please answer the question, I really appreciate it.
Sure. It's Mary's, in my opinion, that this item arose out of an investigative complaint. Non-jurisdictional though it may be, it nonetheless arose out of investigation. So A4 of the exemptions would apply. Also, it's my understanding that there may be some legal questions asked of me during this executive session. And of course, that is permissible as an exemption under A10. Keeping in mind that there will be good faith and strict adherence to the rules of open meetings such that no action of any kind would be taken in an executive session, and all discussion related to activity or action would take place in public session if any action is desired.
Thank you, Ms. Wilton. We deeply appreciate all the comments and of course, Ms. Wilton, your expertise is invaluable. It's time to, if there's any other business, is there any other business out there for the public session?
No, sir.
Hearing none, I'd like to entertain a motion for executive session, please.
So
May I have a mo-
Morgan,
To move for to
Second.
enter executive session.
Executive session motion made by Dr. Horton, seconded by Dr. Taylor. All in favor, say aye.
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 All against, say nay. Hearing none, we're in executive session. Thank you very much. We'll give a few minutes. You want to take 5 minutes? Or anybody want to take 5? We can take 5. I think Alan's got to disconnect everything.
Yeah, I need a couple of minutes, but Dr. Cresswell did have his hand up. I don't know if you wanted to address that.
Okay. Go ahead, Dr. Cresswell. We're in executive session.
Sure. So I did